ಸರ್ ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಅಲ್ಲಿ ಇದ್ದೀರಾ? ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ದಯವಿಟ್ಟು. ಸರ್ ನಾಗರಾಜ್ ಸರ್,
ಸರ್
ನಿಮ್ ಕಡೆಯಿಂದ ಏನೋ ಡಿಸ್ಟರ್ಬೆನ್ಸ್ ಇದೆ ನೋಡಿ ಸರ್.
ಸರ್
ಬಂದೆ.
ಕೋರ್ಟ್ ಆಫೀಸರ್
ಹೇಳಿ
ಸರ್. ಪ್ರಿಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಇದು ಕಾಣಲ್ವಲ್ಲ ಸರ್ ವಿಡಿಯೋದಲ್ಲಿ?
ಏನ್ ಸರ್?
ಪ್ರಿಸೈಡಿಂಗ್ ಆಫೀಸರ್ ಇದು ಕಾಣಲ್ಲ ಅಂತ, ಓನ್ಲಿ ಕೋರ್ಟ್ ಹಾಲ್ ಅದಷ್ಟೇ ಬರ್ತಾ ಇದೆ.
ಅದು ನೀವು ಇವ್ರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡ್ಬೇಕು ಸರ್, ರಿಜಿಸ್ಟ್ರಾರ್ ಜುಡಿಷಿಯಲ್ ಅವ್ರಿಗೆ, ಇಲ್ಲ ರಿಜಿಸ್ಟ್ರಾರ್ ಕಂಪ್ಯೂಟರ್ಸ್.
ಹಾಗಿದ್ರೆ ನಾವು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡೋದು ಯಾವ ತರ ನಮ್ಗೆ ಗೊತ್ತಾಗೋದಿಲ್ವಲ್ಲ ಸರ್?
ಸರ್ ವಿಡಿಯೋ ಬರ್ತಿಲ್ಲ, ವಿಡಿಯೋ ಆಫ್ ಆಗಿದೆ ಕೋರ್ಟ್ದು.
ಯಾವುದು?
ವಿಡಿಯೋ
ನಮ್ಕೊಳಲ್ಲ.
ಆಫ್ ಆಗಿದೆ ಅಂದೆ.
ಮಾಡ್ತಾರೆ.
ಓಕೆ. ಇವಾಗ ಆನ್ ಆಯ್ತು.
Wait. Page wise adjournment, list number 2. Yes. Use. For page wise adjournment, list number 2, page number 1, serial number 2 to 4, page number 2, serial number 5 to 8, page number 3, serial number 9 to 11, page number 4, serial number 12 to 17, page number 5, serial number 18 to 23, page number 6, serial number 24 to 29.
My lord, serial number 25, my lord. Serial number 25. ಇದರಲ್ಲಿ ಬಿ ಪ್ರದೀಪ್ ಇನ್ನೊಂದು ಅಪೀಲ್ ಹಾಕಿದ್ದಾರೆ 2100/20.
Yes. B. Pradeep is directed to take notice for respondent number 2. Take this matter along with the so
2001. ಯಾವಾಗ ಸುಮ್ಮನೆ ಡೇಟ್ ಕೊಡಬಹುದು ಏನು?
next week.
Right.
Page number 7, serial number 30 to 34. Page number 8, serial number 35 to 40. Page number 9, serial number 41 to 48.
My lord, serial number 41, my lord. There are connected
Yes.
2 more appeals are there, my lord. 587 of 21, corporation has filed 1 more appeal. It is a common judgment. And even the respondent also has filed an appeal in the 1042 of 21, my lord.
give the number, madam.
587 of 21,
Sir, there.
900,
Yes.
910 of 21, sir. ಎರಡಿದೆ.
Yes. They let them take. Yes. Learned counsel for the appellant has submitted that this appeal may be called along with its own. Yes.
ಮತ್ತೆ
Page number 10, serial number 49 to 57.
That's number 50, my lord. 50,
Yes.
Ashok and Patil ಹೆಸರು ತೋರಿಸ್ತಾರೆ. My name may be shown.
Yes.
Shri
You have
Shaila.
filed an wakalat.
Yes, my lord. Rasa, yesterday I have received the wakalat also.
Yes. She Shaila. That he has filed an wakalat for.
He will file, my lord. I have not yet filed.
Office is directed to delete the name of Ashok and Patil. Show the name of Sri Shaila for R2.
Much of it.
Page number 11, serial number 58 to 60.
Sorry for my lord.
Yes.
My lord, serial number 55, my lord. Sorry, my lord. Vishwanath Pujari, he said that he has also filed appeal. He is out of station, my lord. So kindly next week, my lord, it may be taken.
Which is that number, Mr. Hegde?
Number I will give, my lord, because he gave some number.
Yes.
1385 or 21,
The
he said I
request
will
of
confirm
counsel
it,
for
I will give
the
it.
parties. Release this matter next week. Number 12.
Connect ಮಾಡ್ಸಕ್.
Along with the petitioner's appeal ಅಂತಂದ್ರೆ ಹಾಕ್ಬಿಡ್ತಾರೆ ಆಫೀಸರ್.
Yes.
Page number 11, serial number 58 to 60. Page number 12, serial number 61 to 63. Page number 13, serial number 6. Page number
64.
13,
You are appearing for? Why you want time, Mr. 2000? Yes, sir. The request of counsel for respondent number 1 to 4. Release this matter of 2 weeks. Yes. 66. The request of counsel for the appellant. Release this matter of 2 weeks.
page number 40, serial number 68 to 71.
The request of counsel for the appellant next week.
Your lordships kindly. Serial number 29.
Request of counsel for the respondent number 1. Release this matter of 2 weeks. Serial number?
29, my lord.
Wait.
Secondly.
Page number 16, serial number 72 to 74.
Yes, which is that, Mr. Nagraj?
My lord, 29, my lord. Second list 29, connected with my lord 5170 of 2021.
Net council for the appellant submits that this appeal may be called along with that. So and so.
Records,
517.
records may be called for 5170 of 2021.
Yes. Have you deposited 50% of that amount?
My lord, by oversight deposited before the tribunal, I will file my,
You file a memo, yes.
please, my lord, please, my lord.
Office is directed to secure original records from the.
Please.
Number 1, for non-compliance of officer objection, first time matter, serial number 1 to 3.
4 weeks,
Second time matter, serial number 4 to
3 weeks,
31. Third time matter, serial number 33 to 34.
2 weeks,
Fourth time matter, 35 to 43.
2 weeks, 4th and 5th, 6, 2 weeks, finally.
Number 2, for being spoken to, serial number 1, station bill for appellant, case of operation.
And I appeal for the respond, my lord. But my appeal is listed in serial number 10, my lord, 8164 of 19. This is corrected with that, my lord.
That, where is that connected matter?
Serial number 10 in the list agide, 8164 of 19.
Yes.
Order submitted.
Yes. What is your case, Mr.
My lord, with regard to quantum, he is continuing in his business. He has admitted in the course of cross-examination that he is continuing his business. And he has produced the income tax returns also. The question of granting compensation on the head of future loss of forex, my lord, does not arise. That is what my contention, my lord, for your lordship.
Records is there.
Bandilla, records bandilla. Is it connected? Nam appeal, nobody has filed the wakalat on behalf of my lord.
Keshav Prashant. Now that serial number 10, why that other insurance company?
But there are two insurance companies.
No, why you have not filed an wakalat, Mr. in that connected matter?
Same address ಕೊಟ್ಟಿದ್ದೀವಿ ಅದೇ ಅಡ್ರೆಸ್ ಅವರ ಅಪೀಲ್ ಅಲ್ಲೂ ಇದೆ ಅವರ ಅಪೀಲ್ ಅಲ್ಲೇ ಬಂದು ಅಪೀಲ್ ಫೈಲ್ ಮಾಡ್ತಾರೆ ನಮ್ಮ ಅಪೀಲ್ ನೋ ಸಚ್ ಅಡ್ರೆಸ್ ಇತ್ತು ವಾಪಸ್ ಬರುತ್ತೆ
The same address is there. No, that the problem is that now I have passed an order, I have to recall. What is that contention, Mr.
Milad, he has produced the income tax returns. Milad, he has admitted in the course of cross-examination he is continuing his business. And he was doing his business in APMCR. That was also accepted in the course of cross-examination. Tribunal Milad still granted the compensation on the head of future loss of earnings considering the disability. My contention is
no, that 5% disability will be there. He may be continued because of 5% disability. He has to sit in the house.
Future loss of income, unless
Future loss of income, 5% is there. Disability. What was earning before that accident is not continued.
Our income tax returns.
Alre 60-70% adra sari 5% disability is there. Accident admale 5% how it will change, Mr. Income taxes also reduce agirtade. I thought that it is more than that 5% disability. That's all.
Disability 5%, Milad, income is considered 43,000. That is the Milad issue. 5,39,000 rupees, Milad, income tax returns filed.
Yes.
Tribunal has considered 43,000 as income, Milad.
What would be that according to you then?
Milad, he has admitted in the course of cross-examination that he is continuing his business and all. So that's why, Milad, I prefer this appeal.
That was posted for being spoken to. Now that connected matter is there, Mr. Without hearing that you have not filed an wakalat, nobody has brought to that notice. Yes. Before order has been signed, the learned counsel for insurance company has moved that memo for being spoken to on the ground that the insurance company has filed an appeal challenging very same judgment and award. In view of that, the order dated 11/10/2022 is recalled. Post this matter along with that
8164
of 2019 next week. You file an wakalat, Mr.
TCR ಒಂದು ತರಿಸ್ಬಿಟ್ಟಿದ್ರೆ ಆಗಿತ್ತು.
Yes, office is directed to secure original records from the prisoner. Yes, Mr. Furnishing of PF. Yes, week's time is granted to. Incomplete address, you furnish correct address. You are respondent. Yes, where is Shauri Raj? Password.
Number 3.
Letter for extension and the trial for disposal of the. This code by order dated 5th October 2021 has directed the tribunal to dispose of that matter 3 months from the date of appearance of the parties. On 23/9/2022, the registry has received a communication from Senior Civil Judge JMFC Nanjangud seeking further extension of time for disposal of the petition. For the reason stated in that communication dated 23/9/2022, further time of 3 months has been granted from today.
Number 4, Maladare for appellant, A.N. Krishnaswamy.
Letter for extension. This court by order dated 7th September 2021. Just page that time. Granted 6 months time to dispose of that petition. By communication dated 22/9/2022 received by Registrar General High Court of Karnataka, the first additional district and session judge Hassan has requested further extension of the time for 3 months to disposal of the case. For the reason stated in that communication dated 22/9/2022, further time of 3 months has been extended.
Number 5, Fountain 38 for appellant, O. Mahesh.
Special order memo for dispensation of R1. Yes, special order.
Disable ಇದೆ sir.
Around 17 ಯಾರಿಗೆ?
ಸಂತೋಷ.
Yes, madam. Learned counsel for the appellant has filed a memo taking dispensation of service of notice to R1. Memo is taken on record. Service of notice to R1 is dispensed. Mahesh. Mahesh, ready? This is not.
Mobile, O. Mahesh.
Yes, next week.
Excellent.
Yes.
Number 6, Ajay Kamruti.
My lord, I appear for the appellant, my lord.
Yes,
LCRs, my lord, have to come in this matter.
it's required.
It will be required, my lord. I have challenged the fastening of liability as well as the quantum, my lord.
Yes. You are appearing for?
Appellant, my lord. Appellant.
Appellant is that insurance company.
No, my lord. Individual. There is no insurance there.
Owner.
Owner.
Yes.
My lord, interim order may be extended, my lord.
How to admit. Interim order granted earlier is extended till next date. What is that interim order?
My lord, they have filed an execution. We have to stay that, my lord.
Interim order granted earlier is extended till next date of hearing.
Grateful.
Number 7, Karnataka for appellant, A. Ravishankar.
I appear for the respondent.
Yes.
Really?
For dispensation of notice to R1 and R2.
ಅಲ್ಲ ಅದಿದು ಏನಾಗಿದೆ ಅಂದ್ರೆ ಇಟ್ಸ್ ಕೇಸ್ ಆಫ್ ಇಂಜುರಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್ ಅಲ್ಲ ಅದು ಅವರು ದ ಕ್ಲೈಮೆಂಟ್ ಹಿಮ್ಸೆಲ್ಫ್ ಹಸ್ ಕಮ್ ಆನ್ ಅಪೀಲ್ ಸೊ ಹಿ ಅಕಾರ್ಡಿಂಗ್ ಟು ದೆಮ್ ದೇ ಹಸ್ ಪಾಸ್ಡ್ office objection raised on IA1 for bringing LRs of deceased appellant. So he was the injured person who died. The LRs may not be entitled for enhancement.
No, that now recent Supreme Court judgment said some extent they are entitled. Even that injury case.
They are entitled. They may not. He may not be. It amounts to an estate. They are entitled for the sum awarded by the tribunal. They will not be entitled for.
Yes.
ಇದನ್ನ ಎನ್ಹಾನ್ಸ್ಮೆಂಟ್ ಮಾಡಕ್ ಬರಲ್ಲ ಇದ್ದಿದ್ ದುಡ್ಡು ಕೊಡ್ಬೇಕಾಗುತ್ತೆ ನಾವು
No, they can be entitled. I think recent Supreme Court judgment. What is... Yes, recently Supreme Court said they can.
He is not aware.
Yes, 21. Yes, you have any objection for bringing LRs?
Yes, madam, I will file objections.
Yes, it's fine.
Let him serve the copy. He has not served the copy. Mr. Shantaraj has not served the copy.
Yes. Learned counsel for the appellant is directed to serve one set of IS copies to respondent. Number 3. Ravishankar pays 2 weeks time to file an objection to that IA.
Great.
Number 8, the Karnataka for appellant, United India Insurance. Case is injury case.
Yes, United India Insurance, you are there. Ravish Vinina. Yes. Federal. Ready. First is MEC. 794. Or 795. First is 7. Which is that page?
Amputation. Below elbow amputation is good.
Yes.
After there is a disability. 8%.
Yes. Where is the discussion in which paragraph? 28. Loss of future in person established that due to the impact of accident, injury, amputation of lower one-third more than become visible. Financially in this class exam is to deny the professor. Tribunal ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ತಗೊಂಡಿದ್ದಾರೆ? Yes. What is that doctor evidence? The below elbow amputation with skin grafting was done under the so patient was asking to take and follow treatment. Permanent disability, the reason is 69%. ಕೊಡಿ ಇದ್ರಲ್ಲಿ ವರ್ಕ್ಮೆನ್ ಕಾಂಪನ್ಸೇಷನ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಎಷ್ಟಿದೆ? ಎಲ್ಬೋ Yes, Mr. No, now that his elbow has been amputated, now you have to be considered for his functional disability as a coolie. We will secure the records. Office is directed to secure. Sri Ravish Bini is direct to take notice. He has filed an wakalat for respondent number 2. Office is directed to show his name for respondent number 2. Notice to R1 is dispensed. delay of 116 days is condoned. IA-1 of 2019 is allowed. Office is directed to secure original records from the tribunal first immediately after receipt. Now we have to see is the evidence and functional disability has to be considered. Serial number? Oh, that is not injury. Yes, 8.1 could be. It's only for MFA 4061. 4055, yes. Yes. Page 16, 44 years. 44 years. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಇನ್ಕಮ್ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು 1500 170. Yes. What is the deduction? Future prospects ತಗೊಂಡಿದ್ದಾರಾ 25%. 1/3 ಮಾಡಿದ್ದಾರೆ. Yes, that will consider. Who are the claimants? Yes, Mr. That's all. Three, Shantraj, a learned counsel appearing for the insurance claimant has contended that at the time of the accident, deceased was aged about 44 years. He was doing a coolie and earning 15,000 per month. The tribunal has assessed notional income of the deceased as 15,500 per month is on lawyer side. It further contended that in view of judgment of apex court in case of Pranay Sethi, 25% of the income of the deceased has to be added for future prospects. Lastly, he has contended that in view of judgment of apex court in case of Magma, the claimants are entitled 40,000 each. Hence, he sought for enhancement of compensation. For contra, Shri Binny, learned counsel appearing for the insurance company, has contended that even though the claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the deceased as 10,500. Further contended that since the claimant has failed to establish his income, the tribunal has rightly not granted any compensation for future prospects. Lastly, he has contended that considering the age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. And he contended that interest awarded by the tribunal 7% is on higher side. Heard the learned counsel for the parties. There was judgment and award. Shri Nagendra died in road traffic accident on 22/4/2017 due to rash and negligent driving of rider of motorcycle bearing registration number KA lorry, driver of the lorry bearing registration number KA014057. Even though the claimant has claimed that deceased was earning 15,000 per month, they have not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. In view of judgment of apex court in case of Pranay Sethi. 25% of the income of the deceased has to be added for future prospects. At the time of the accident, deceased was aged about 44 years. The multiplier applicable to that age group is 14. Accordingly, loss of dependency has been reassessed as follows.
11,000 plus 2,750 at the rate of 25%, 13,750 minus 4,580 at the rate of 1/3, 10,167, 10,167 into 12 into 40, 15 lakhs, 40,000, 056.
In addition, 15,000 for loss of estate, 15,000 for criminal expenses. In view of judgment of apex court in case of Najma, the first claimant is entitled 40,000 for spousal consortium. LA. Where is that? Is there any judgment? ಅಲ್ಲ 44 ಇದಕ್ಕೆ ಕನ್ವೆನ್ಷನಲ್ ಆಗಿ ಯಾವ್ದು 3,000 ಅದು ಅಂದ್ರೆ 18 ಅದೇ 18 33 1,500 ಜಾಸ್ತಿ 33,000 44,000 each. 44,000 for claimant, first claimant for spousal consortium, and 44,000 for second claimant for a parental consortium. Accordingly, the appeal is allowed in part. Judgment and award passed. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Yes. This Vinny is there. Yes. Yes, Mr. ಯಾವ್ದ್ರಲ್ಲಿ? Yes. Who is the auto? Owner. What is the necessity then? If it is, your liability is there. Unless he is fostering liability, he is not necessary party. ಯಾವ್ದು? ಅಲ್ಲ ಯಾವ ಕೇಸ್ ರೆಫರ್ ಮಾಡಿದೆ? ಆಯ್ತು, ರೆಫರ್ ಮಾಡಿದ್ರು ಕೂಡ till that the law which has been laid down has to be continued. That is what Supreme Court said. You can't wait till the No, which bench has heard? ಏನಾಗಿದೆ? Reserve. But Supreme Court said, even see, Supreme Court said, when the matter has been referred to the larger bench, the law which has been laid down has to be prevailed till the see, Mukund Devagan case. No, that is not that. We can't wait that. On that case is only we have decided that. On very case it. ನಾನು ಡಿಸೈಡ್ ಮಾಡಿದ್ದೀನಿ. Justice Dixis is also decided on OMIS case. We have held referring the Supreme Court judgment. He cannot be wait till that reference has to be decided. Next week, I will. Alalala, even if it is referred to the larger bench, it cannot be wait. That is what. Then refer made Mukund Devan case last year itself I have decided and I am passing that order. That judgment I will place next week. Yes. Next week. Next week. Yes. ಯಾಕಂದ್ರೆ most of the matters is on that. If I say in one case, ಅದೇ, if I say, then all matter will be again held up. Yes, call this matter along with that so and so. ಇದರಲ್ಲಿ the manager Reliance Insurance Company ಯಾರು ಇದ್ದಾರೆ? ಆಯ್ತು, ಅದ್ರ ಜೊತೆ ಬರ್ಲಿ. Yes, Mr. Yes. Karnataka Council for the Appellant has filed a memo seeking dispensation of service of notice to R1. Memo is taken on record. Notice to R1 is dispensed at the risk of the appellant. 899 days delay in filing appeal is condoned, not entitled for the interest. At the request of the parties, refer the matter to local.
Number 12, Manjunath Reddy for appellant, Janardhan Reddy.
You want to withdraw? Karnataka Council for the Appellant has filed a memo. It is 13/10/20. Henry 2022 ಬರೆಯೋದು ಬಿಟ್ಟು ಬರೀ 20 ಬರ್ಕ್ ಕೊಟ್ಟಿರಲ್ರಿ. Give of this court to withdraw the appeal. Anyhow, he is withdrawing that. Why have? Yes, memo is taken on record. The above appeal is dismissed as withdrawn. Dated 13/10/2022. All pending application has been disposed of. Yes. Memo for dispensation to R1 is dispensed. Delay of 167 days condoned, not entitled for the interest. Ready? Yes, madam.
Accident on 2018. The income taken by the citizen is 12,000 rupees.
What is your claim?
12,500 should be taken.
No, how much you have claimed? Monthly income, what is your monthly income, madam?
35,000 rupees.
What is the disability?
Percentage to the lower limb reduction.
How
Left
much?
lobe,
Tribunal has taken?
6%.
Correct.
One previous injury alone.
Yes.
47 years.
What is that? How many days you are in hospital?
8 days.
Pain and agony. Out of immunities. Rest of nutrition, expenses, loss of income during the later period. Medical expenses. What is that interest awarded? 8%. Yes, that's all. Yes. Yes, mister. Yes, sir. Yes, yes. Amenities, I will consider. But so Karnataka Council appearing for the claimant has contended that at the time of the accident, he was earning 25,000 per month. The tribunal has considered the notional income of the claimant as 12,000 is on lower side. She further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 8 days. He has suffered a lot of pain during the treatment. He has to suffer the disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lawyer side. Hence, he sought for enhancement of compensation. For contra, Krishna Kishore Learned Counsel appearing for the insurance company has contended that even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 12,000 per month. He further contended that the injury suffered by the claimant's minor in nature was inpatient only for a period of 8 days. Considering that the evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Feroz, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on it is 18/2/2018 due to rash and negligent driving of driver of car bearing registration number KN18 MC 959. Due to that accident, the claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities. What is that? 6%. Even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2018, the notional income has to be considered as 12,500. At the time of the accident, he was aged about 47 years. The multiplier applicable to the age group is 13. Accordingly, loss of future earning has been reassessed. Due to that accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 8 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and agony from 25,000 to 50,000. Loss of immunities from 20,000 to 40,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. The enhanced compensation amount carries 6% interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as well.
67 days.
160?
167.
Yes. In view of order dated so and so, the claimant is not entitled for the interest for a period of 167 days. Medical expenses retained. Yes. Ready? Notice to R1 is dispensed. 63 days delays condoned. Yes. 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 What is that income? How much you are earning? 25,000. Tribunal ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ? 2016. Where is that discussion? Notional income 12,000. What is that disability, Mr.? Loss of income due to the disability, there is no dispute. Only in respect of other head. Yes. Where is that chart? Synopsis. Yes. Huh? Medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ. Maintenance charges 25 ಕೊಟ್ಟಿದ್ದಾರೆ. Pain and suffering 50 ಕೊಟ್ಟಿದ್ದಾರೆ. Amenities ಒಂದು ಕೊಟ್ಟಿಲ್ಲ. Loss of income during the later period. ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಅಲ್ಲಿ ಇದೆ 35. ಎಷ್ಟು ಇದು ಮಾಡಿದ್ದಾರೆ? 12, 45, 50, 60,000 ರೂಪಾಯಿ ಗ್ಲೋಬಲಿ ಪ್ಲಸ್. ಎಸ್ ಮಿಸ್ಟರ್. What is the future prospects? ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಡಿಸಬಿಲಿಟಿ? 12% ಈಗಲ್ಲ ಇಲ್ಲ. 12%. ಎಸ್, 12% ಈಗಲ್ಲ ಇಲ್ಲ. 25% ಮೇಲಾದ್ರೆ we can see whether it will affect your avocation. Then we can consider. Yes, Karnataka Council for the appellant has contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 35 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal, pain and suffering, and other incidental expenses is on lower side. The tribunal has failed to grant any compensation for loss of immunities. Hence, he sought for enhancement of compensation. For contra, Jagdish Learned Council appearing for insurance company has contended that the injuries suffered by the claimants are minor in nature. He was inpatient only for a period of 25 days. Considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, Peros, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 3/2/2016 due to rash and negligent driving of driver of car bearing registration number K05 MD5531. Due to that accident, the claimant has suffered the following injury. The tribunal has rightly assessed the whole body disability is 12%. Due to that accident, the claimant has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and considering that injury suffered by the claimant, I am of the opinion, in addition to that compensation awarded by the tribunal, 60,000 has been awarded with 6% interest. Yes. Notice to R1 is dispensed. 122 days delay condoned. Ready? Yes. Yes, madam.
The date of accident is 18/9/2017.
Yes.
He was 4 years at the time of accident.
Yes.
Occupation is agricultural work.
Yes.
His income was 30,000 rupees per month.
Yes. What is that tribunal has considered income? 2017. Yes. What is that disability? ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು?
9 has been taken by the tribunal.
PWSO certificate issued by the custody after the faithful movements using from 1/6 so and so. Orthopedic surgeon reports that accident is so and so. Therefore, considering the nature of injury treatment, I will consider institutional to the hospital.
It is fracture shell also, which are grievous in nature.
Now, where is that discussion regarding that disability?
9 of University Judgment,
Yes.
para 13. Issue number 3.
Hmm.
Exhibit P7 is a copy of the wound certificate issued by the Kasturba Hospital, Manipal, and it discloses that the petitioner has sustained swelling and deformity.
No, doctor has not said what is the disability and all. ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ? ಇದೆಯಾ? ಎಷ್ಟು ಹೇಳಿದ್ದಾರೆ?
Percentage.
8.
8% to the left upper limb.
Hmm.
40% to the right upper limb.
ಇದ್ಮೇಲೆ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ?
9% is being taken by the people.
ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ. Income is also right. Yes. Then only that other head.
Yes, sir.
What is the?
10 you are-
9% is 1% will not make any difference, madam. We'll consider in that other this thing.
Okay, Lord.
Yes. 8% interest. 40. Pain and suffering on the equal to ಯಾವ್ದ್ರಲ್ಲಿ? Pain and suffering on 20,000. Amenities on 20,000. ಆಮೇಲೆ ಲಾಸ್ ಆಫ್ ಇನ್ಕಮ್ ಡ್ಯೂರಿಂಗ್ ದ ಲೇಟರ್ ಪೀರಿಯಡ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 60. Yes, will globally will enhance 60,000. Yes, madam. 70,000. Yes. Enhanced compensation carries 6% interest. Yes. So and so for 80,000. Yes. So and so learned counsel appearing for the claimant has contended that. How many days you were in that hospital? 8 days. Due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 10 days. He has suffered lot of pain during the treatment. He has suffered. The tribunal has he has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lawyer side. Hence, he sought for enhancement of compensation. Per contra, Shri Krishna Kishore Learned Counsel appearing for the insurance company has contended that the injuries suffered by the claimants are minor in nature. He was inpatient only for a period of 10 days. Considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. And he further contended that the interest awarded by the tribunal 8% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 18/9/2017 due to rash and negligent driving of rider of motorcycle bearing registration number AA20 EM 9160. Due to that accident, the claimant has suffered the following injury. That considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities 9%. The claimant has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and considering that injury suffered by the claimant, I am of the opinion, in addition to the compensation awarded by the tribunal, 80,000 has been awarded without any interest. Accordingly, the appeal is allowed in court. Yes, without any interest for enhanced compensation. Notice to R1 is dispensed, delays control. Yes. This appeal may be called along with that so and so. Yes. Notice to R1 is dispensed during 15 days. Where is Ramkrishna? Password.
Kugadde.
Ready? Notice to R1 is dispensed. Delay of 226 days, condone not entitled for the interest. Yes. Yes. 2000? Yes. What is that income? ಅವರೆಷ್ಟು 25,000 ಕೇಳಿದ್ರಾ? Electrician 8,000 ತಗೊಂಡಿದ್ದಾರಾ? 2016 ಎಷ್ಟಿದೆ? 9,500. What is his age? 27 years. What about that disability? Huh? How much? But ಎಲ್ಲಿದೆ discussion? He is sustained to that permanent disability and he is not in position to work. As such, he is sustained future loss. Krishna Ramchandra, Professor Victoria, orthopedic, stated that petitioner deserves lawyer leave to that whole body 16%. Cross examination. ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ ಟ್ರಿಬ್ಯುನಲ್ ಅವರು? ಡಿಸಬಿಲಿಟಿ ಎಷ್ಟು ಪರ್ಸೆಂಟ್ ತಗೊಂಡಿದ್ದಾರಪ್ಪ? 10% ತಗೊಂಡಿದ್ದಾರೆ. Why no personal disability? Disability has to be reassessed, Mr. Doctor said 16. Barala stated that petitioner sustained 32 disability to the lower limb. Yeah. Yes, how many days he was in the hospital? Huh? Yes, pain and suffering, actual medical expenses, diet conveniences of Sara, loss of earning during the treatment period. Students ಇದು amenities ಕೊಟ್ಟಿಲ್ಲ. Yes. Interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 6%. Yes, that's all. That so and so learned counsel appearing for the claimant has contended that at the time of the accident he was earning 25,000 as an electrician. The tribunal has considered the notional income of the claimant as 8,000 per month is on lawyer side. She further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 26 days. He has examined the doctor as PW2. In his evidence, he has deposed that the claimant has suffered 32% disability to left lower limb, 16% to whole body. The tribunal has assessed whole body disability 10% is on lower side. She further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 26 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of amenities, pain and suffering, and other incidental expenses is on lower side. The tribunal is failed to grant any compensation for loss of amenities. Hence, she sought for enhancement of compensation. For contra, B. Pradeep, learned counsel appearing for the insurance company has contended that even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that considering that injury suffered by the climate and considering that the evidence of the doctor, the tribunal has rightly assessed whole body disabilities 10%. He would further contended that the injuries suffered by the claimants are minor in nature. He was inpatient only for a period of 26 days. Considering that the evidence of doctor and considering that injuries suffered by the claimant, the compensation awarded by the tribunal, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Arose judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 6/6/2016 due to rash and negligent driving of rider of motorcycle, rider of active Honda wearing registration number K05 JM 8566. Due to that accident, the claimant has suffered the following injury. He has examined Dr. S. Ramchandra as PW2. In his evidence, he has deposed that the claimant has suffered 32% disability to lower limb and 16% to whole body. Considering that the evidence of doctor and injury suffered by the claimant, I am of the opinion that whole body disabilities has to be assessed 12%. Even though the claimant has claimed that he was earning 25,000 per month, he has not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about 27 years. The multiplier applicable to the age group is 17. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 26 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that the evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of earning during the treatment period for 3 months. The claimant is also entitled for loss of immunities, 40,000. The compensation awarded by the tribunal in the other hand are just and reasonable. Accordingly, 3 months ಕೊಟ್ಟಿದೀವಲ್ಲ madam. Yes. Accordingly, the appeal is allowed in part. Judgment and award passed for the tribunal. Not entitled for the interest for a period of 226 days. United India Insurance ಯಾರಿದ್ದೀರಾ? United India. Yes. Respondent number 2 served unrepresented. Also is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies. Next week, death case notice. Yes. Ready, madam. Yes. Office objection raised on the wakalat filed by so signature forthcoming. 153 days delay condoned, not entitled for the interest. Yes, Mr. Sri. Yes. 16. Yes. How much you are earning? 1,000. Yes. Tribunal has taken how much? Tribunal has taken 10,000. Disability? Where is that discussion? Yes. The doctor has assessed the disability 22% of petitioner, but doctor has not produced any disability in the class examination because of he has said that it is a limb disability. 8% correct. Yes. How many days in the hospital? 6 days. Pain and suffering, medical expenses, diet, loss of income during the treatment period, 3 months. Support loss, discomfort and frustration, and loss of immunities. Yes, madam. Yes. 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 No, but as per that Lok Adalat chart, it should be 9,500. Yes. 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 But we are not touching the disability. That we are not. Yes. 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 We'll consider. Yes. 3. Yes. Yes. 3. We must be learned counsel appearing for the claimant has contended that at the time of the accident, the claimant was earning 10,000 per month. The tribunal has assessed notional income of the claimant as 9,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 6 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. Srimati Lata Prasad, learned counsel appearing for the insurance company has contended that even though the claimant has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 9,000 per month. She further contended that the injuries suffered by the claimant are minor in nature. He was inpatient only for a period of 6 days. Considering that evidence of doctor, the injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Lastly, she has contended that the interest awarded by the tribunal, 9% is on higher side. Hence, she sought for dismissal of the appeal. Yes, madam. Any Yes. 5 days. 5 days. Yes, we'll consider. Heard the learned counsel for the parties. Theros, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 6/11/2016 due to rash and negligent driving of rider of motorcycle bearing registration number KA11 EG 5020. Due to that accident, the claimant has suffered the following injury. Considering that evidence of doctor and injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities 9%, 8%. Even though the claimant has claimed that he was earning 10,000 per month, he has not produced any document to establish the same. Under the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2016, the notional income has to be considered as 9,500. At the time of the accident, he was aged about 36 years. The multiplier applicable to the age group is 15. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, the claimant has suffered the above said injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 30,000 to 50,000. Loss of immunities from 30,000 to 40,000. Loss of income during the later period for 3 months. The compensation awarded by the tribunal in the other hand are just and reasonable. The enhanced compensation amount carries 6% interest. The claimant is not entitled for the interest for a period of 153 days. Signature. You have not signed that wakalat, madam. Just sign. Yes. Memo for dispensation furnishing of notice to second time. Liberty video ayari there. You are there, Mr. Ravi Sampath. You are there. You there, Ravi, yes. Ravi Samprati is directed to take notice for respondent number 2. Learned counsel for the appellant is directed to serve one set of copies on Ravi Samprati. Notice to R1 is dispensed at the risk of the appellant. Copy kodi everyone. ಯಾರೋ ಕನೆಕ್ಟ್ ಮಾಡಕ್ ಹೇಳಿದಾರೆ. ವೆಂಕಟೇಶ್ ಅವ್ರು ಹಾಕಿದಾರಾ? ಅದ್ರಲ್ಲಿ ಏನ್ ವೆಂಕಟೇಶ್ ಇಸ್ ಡೈರೆಕ್ಟೆಡ್ ಟು ಟೇಕ್ ನೋಟಿಸ್ ಮಾಡಿ ಅವ್ರ ಹೆಸರು ತೆಗೆದ್ಬಿಟ್ಟು please this matter along with the sound. Dispensation of notice to R1 is dispensed. If got okay, Murlidhar is direct. R2 is served unrepresented. Murlidhar is directed to take notice for respondent number 2. Counsel for the appellant is directed to serve one set of copies. Yes. ಯಾರ್ದದು ಅದ್ರಲ್ಲಿ ಯಾರು ಫೈಲ್ ಮಾಡಿದ್ದಾರೆ? Post this matter along with the sounds.
Serial number 23 and 24, man.
Yes. You have filed an appellant.
Universal sample may I take, my note?
Yes, yes. Respondent number 2 is served unrepresented. Egde is directed to take notice for respondent number 2. Notice to R1 is dispensed. Learned counsel for the appellant is directed to serve one set of copies. Next week. Did I verify?
After 10 days, my lord, after 2 weeks, my lord, because
2 weeks.
Bombay office,
2 weeks.
so next my lord,
Negligence is directed to take notice for respondent number 2. Learned counsel for the first row. Notice to R1 is dispensed. Delay of 5 days is condoned. R2 is served unrepresented. Negligence is directed to take notice. Counsel for the appellant is directed to serve one set of copies. Yes.
Much obliged.
Number 26, Pradeep KC for appellant. Liberty Videocon General Insurance.
Liberty Videocon ಯಾರಿದ್ದಾರೆ?
Ravi Samprati is appearing, my lord. Ravi Samprati.
Yes. R1 notice dispensed. R2 served unrepresented. Ravi Samprati is directed to take notice. Learned counsel for the appellant is directed to serve one set of copies.
Number 27, Balakumar for appellant.
Yes, Mr. Jalakumar.
I pray for 1 week's time to take steps, madam.
Each time is granted to do the needful.
Much.
Number 58, Pradeep for appellant. Yes, sir.
Yes. Have you deposited? You file an execution. Yes. At the request of counsel for the appellant, release this matter after 2 weeks. I will not extend any interim order and all. Yes.
Number 29, action. Number 30, DSW for appellant.
Yes, they have not deposited. You file an execution. No, if the interim order is subject to condition, if they have not paid it or deposit, that interim order will not be continued at all. Therefore, you need not file an vacating. You need not seek for this thing. You can file an execution at all. Yes. You file an execution, then they will immediately deposit. Yes. None appear for the appellant. Release this matter after 2 weeks. That is that understanding. Interim order is granted subject to payment of 50,000, 50% within 4 weeks. That means to say, interim order will not be continued after that. Yes.
Number 31, yes, Girish for appellant.
Yes, Mr. Girish. R1, notice to R1, dispensed. Directed to take notice. Directed to serve one set of copies on Janaband. Yes, next week.
32, Gurudeva Prasad Pet.
Yes. Yes, Sanmati. Why Sanmati is not coming? Huh? Out of station. Password.
For appellant.
Manjunath ND. Has to be taken in respect of deceased respondent. Each time is granted to do the needful.
Number 34, Kantaraj case for appellant. Kishore Kumar Reddy.
Yes, Kishore Kumar Reddy. Prakash Beka. 32, Gurudev Prasad. Password. Urban. Ready. Oh, claim dismissal. Yes. Notice to R2 is dispensed. No, I said that if Sanmati comes, we can decide for a delay and admit that matter. Password, let it come. Yes. Otherwise, it will post again for condonation of delay.
34, Kantaraj case for appellant. Kishore Kumar Reddy.
Where is Kishore Kumar Reddy? Password. Yes.
Number 35, Pradeep for appellant.
Acceptance of returns of check. What is this, Mr. Pradeep?
ಚೆಕ್
ಗಂಟೆ ಆಗಿದೆಯಾ? ನೋಟಿಸ್ ಆಗಿದೆ ಅಷ್ಟೇ. ವೇರ್ ಇಸ್ ಯುವರ್ ಅಪ್ಲಿಕೇಶನ್ ಫಾರ್ ಸ್ಟೇ? ಅಪ್ಲಿಕೇಶನ್ ಇದೆಯೇನ್ರಿ? ಮತ್ತೆ ಅದೇ ಪೋಸ್ಟ್ ಮಾಡಿದ್ದೆ. Yes, heard.
IA 1 of 22.
Heard the learned counsel for the appellant on IA 1 of. On what ground you have challenged, mister? On IA 1 of 2022. Delay nila. Stay up. Judgment and award dated 5th January 2022. Passed by MESCT Bangalore in MESC 382 of 2020, subject to deposit of 50% of the award amount before this court with interest before this court. Entire amount deposit madidira, subject to deposit of entire award amount before this court. The office is directed to accept that check deposited by the appellant. Yes. Vijay Kumar, finishing up PF issue notice. Week's time is granted to do the needful.
Interrogatory application matter, serial number 37, with Prakash for appellant, Muralidhar Megawar.
Yes, delay is controlled. IA 1 of 2018 is allowed. Ready? Office is directed to secure original records from the tribunal.
38 is please for appellant, Pradeep.
Yes. Ready? Ready, Mr. Pradeep. Delay of 214 days is condoned, not entitled for the interest for enhanced compensation amount. Yes. Yes. The discussion. Para 14. Working as an 15,000. Criminal estate is there. What is the date of accident? Where is that discussion regarding the disability? For that examination, the petitioner has sustained permanent physical disability 14% to the left lower limb, 43%, 14% whole body. Yes, considered so and so. Yes, tribunal estandiದ್ದಾರೆ. How many days in that hospital, Mr.? 5 days. What is that? Pain and suffering 40. Mental agony. Actual medical expenses ಕೊಟ್ಟಿದ್ದಾರೆ for special diet conveyances, permanent disability, future medical expenses. Loss of immunities ಕೊಟ್ಟಿಲ್ಲ. Immunities and later period. Yes, interest. Wait, interest 6%. Yes, now you. Yes. Krishna. You are challenging the 10%. Yes. Where is that finding?
There is no penetration class. The access part.
Records. You have anybody else have sketch and Accident occurred 3 feet distance to the western edge of the Harinagara Karnataka main road. There is no pedestrian crossing by accident spot and the petitioner is crossing. Now that you are crossing from which side to which side? Now that you have crossed 90% or you have crossed only 30%. Whether you are crossing from west or east to west or west to east. ಪೂರ್ವದಲ್ಲಿ 3 ಅಡಿ ಇದೆ. East to west you are crossing. Then he has already crossed 90%, mister. See, if he is crossing here, then it is his fault. He has crossed 90%. You have, see that your, which is that vehicle number K05. It has come extreme left side and dash. Yes. Only reason they have given that there is no pedestrian crossing. Bangalore all. Yes. Yes, mister. What else? That's all. Interest ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ? 6%. Yes. Yes, Shri. Yes, Girish, Learned Council appearing for the climate has contended that the accident is occurred due to rash and negligent driving of rider of motorcycle bearing registration number KA05 JS2943. The climate was crossing the road from east to west. He has crossed 90% of the road. The rider of the motorcycle has come extreme left side and dashed against that climate. The tribunal is error in held that the climate has contributed 10% to the accident. He contended that it is very clear from the spot sketch and Mahazor that rider of the motorcycle alone is negligent in causing the accident. Contrary to that material available on record, the tribunal has given a finding that climate has contributed 10% to the accident. In respect of quantum, he has contended that due to that accident, the climate has suffered grievous injury. He has examined the doctor. Which is that paragraph? Session, which paragraph you read? 15. Yes, he has examined the doctor as PW2. In his evidence, he has categorically deposed that the climate has suffered 43% disability to left lower limb and 14% to whole body. The tribunal has assessed the whole body disability, 9% is on lower side. He further contended that at the time of the accident, the claimant was earning 15,000 per month. The tribunal has considered the notional income of the claimant as 8,000 per month is on lower side. He would further contended that due to the accident, the claimant has suffered grievous injury. He was inpatient for a period of how many days you were there? 5 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering and other incidental expenses is on lower side. The tribunal has failed to grant any compensation for loss of immunities and loss of income during the later period. Hence, he sought for enhancement of compensation. For contra, Sri B. Pradeep, Learned Council appearing for the insurance company has contended that the accident is occurred due to the rash and negligent. It is due to the contributory negligence of climate as well as rider of the motorcycle bearing registration number AA05 JS2943. The claimant is also contributed 10% to the extent. He was crossing the road where there was no zebra crossing. Therefore, the tribunal has rightly held that the claimant has contributed 10% to the extent. In respect of quantum, he has contended that even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that the tribunal, after considering the evidence of Dr. PW2 and considering that injury suffered by the claimant, has rightly assessed the whole body disabilities 9%. Lastly, he has contended that the injuries suffered by the claimants are minor in nature. He was inpatient only for a period of 5 days. Considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, Feroz, judgment and award. The advocates are made available the certified copies of the original records. The case of the claimants that on 28/7/2017 at about 1:45 p.m. She was crossing the road in Konanagunte main road near Surabhi Hotel from east to west direction. The rider of the active Honda bearing registration number AA05 JS2943 has ridden the same in rash and negligent manner, dashed against the claimant. Due to impact, she fell down as she suffered an injury. Immediately, she has been shifted to the hospital. After recovering from the injury, she has filed that claim petition. To prove her case, she has examined herself as PW1 and produced 13 documents. As per the sketch exhibit P3, it is very clear that the road was proceeding from north to south. The claimant was crossing from east to west. She has crossed 90% of the road. The motorcycle, which is coming from south towards north, has come extreme right side and dashed against the claimant. It is very clear from the spot check, major and complaint that the rider of the motorcycle alone is negligent in causing the accident. The tribunal is error in held that the claimant has contributed 10% to the accident. In respect of quantum is concerned, due to the accident, the claimant has suffered the following injury. He has examined Dr. Nagaraj DN as PW2. In his evidence, he has deposed that the claimant has suffered permanent physical disability 43% to left lower limb and 14% to whole body. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the whole body disability has to be assessed 14%. Even though the claimant has claimed that she was earning 15,000 per month. She has not produced any document to establish the same. Under those circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurred in 2017, the notional income has to be considered as 11,000. At the time of the accident, the claimant was aged about 27 years. The multiplier applicable to that age group is 17. Accordingly, loss of future earning has been reassessed as follows. Due to that accident, the claimant has suffered the opposite injury. She was inpatient for a period of 5 days. She has suffered lot of pain during the treatment. She has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am of the opinion that the claimant is also in the. I am inclined to enhance the compensation for pain and suffering from 40,000 to 60,000. The claimant is also entitled for loss of income during the later period for 3 months and loss of amenities 40,000. The insurance company is directed to deposit the entire compensation amount with 6% interest within 6 weeks from date of first copy. The claimant is not entitled for the interest for a period of 214 days.
I'm appearing for the appellate, Miller.
Yes,
Appearing
Yes,
for the
sir.
appellate.
Ready,
Claimant's appeal for enhancement. Ma'am.
Ready?
Please,
Ready,
ma'am,
ma'am.
please.
We have 394 days and not entitled for the interest.
It's only income has to be reconsidered, my lord. Accident is of the year 2017. Income
Yes.
has considered only 88,000, my lord. Further, pain and suffering, loss of amenities and loss of earning during later period has to be reconsidered. Ma'am.
Yes. What is that monthly income you are earning?
You are earning 20,000 per month. So he was working as a fabrication worker.
Yes. 2017 under 11,000.
11,000.
ಎಷ್ಟು ದಿನ ಹಾಸ್ಪಿಟಲ್ ಇದ್ರಿ?
For 5 days.
What is the disability assessed by the tribunal?
Tribunal has the doctor has assessed 48% to the left leg and the tribunal considers 16% to the whole body.
Yes, it is right.
The pain and suffering is awarded only 15,000, my lord. As far as the loss of earning during later period is only 10,000 and amenities is only 10,000.
Yes, where is that?
Discussion at the
Medical expenses, food and nourishment, treatment, lot of earning during the treatment. 2 months.
issue number 3, para number 14, my lord.
Pain and suffering, future medical expenses, amenities. Yes, Mr. Egde.
Yes, it can be.
That's all.
Please, my lord, please.
So and so learned counsel appearing for the claimant has contended that at the time of the accident, he was earning 20,000 per month. The tribunal has assessed notional income of the claimant as 8,000 per month is on lower side. He further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 5 days. He has suffered lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering and other incidental expenses is on lower side. The tribunal is failed to grant any compensation for loss of amenities. Hence, he sought for enhancement of compensation. For contra, Shri Hegde, learned counsel appearing for insurance company has contended that even though the claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 8,000 per month. He further contended that considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Theros, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 29/9/2017 due to rash and negligent driving of driver of car bearing registration number P11 M6051. Due to that accident, the claimant has suffered the following injury. Considering that evidence of doctor and considering that injury suffered by the claimant, the tribunal has rightly assessed the whole body disabilities at 16%. Even though the claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. In such circumstances, the notional income has to be considered as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2017, the notional income has to be considered as 11,000. At the time of the accident, he was aged about 29 years. The multiplier applicable to the age group is 17. Accordingly, loss of future earnings has been reassessed as follows. 59,040. Due to that accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 5 days. He has suffered a lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal. Hence, I incline to enhance the compensation for pain and suffering from 15,000 to 35,000. Loss of income as granted for 2 months. The claimant is also entitled for loss of immunities has to be granted for 30,000. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows.
Parent suffering 15 ಅಲ್ಲ 10,000 10,000 to 25,000. Parent suffering
10 ಇದೆ. 10 ಇಂದ
ಇಲ್ಲ 15 ಇದೆ ಸರ್ 15 ಇದೆ.
ಪೇನ್ ಅಂಡ್ ಸಫರಿಂಗ್ ಎಷ್ಟಿದೆ ಹೇಳಿ?
15 ಇದೆ ಸರ್. 15 ಇದೆ. No. Pain and suffering is 15.
ಅಲ್ಲ ನೋಡಿ pain and suffering 10,000 ಅಂತ ಪ್ಯಾರಾಗ್ರಾಫ್ ಪೇಜ್ 11 ದಲ್ಲಿ ಇದೆ. Page 15.
Permanent disability. No, pain and suffering is
10,000.
15 ಅಂತಿದೆಯಲ್ಲ. Any of that pain and suffering has to be enhanced to 35,000.
Please, madam. Please.
Whatever may be that now I am
Please.
enhancing to 35,000.
Please, madam.
Not entitled for the interest for a period of 395 days.
Much obliged.
Delay 483 days control not entitled for the interest. Yes. Correct. Admission matter, serial number 42, Prakash M40 for appellant, Geeta Raj. Yes. Ready, madam? (2009) accident. Income ಎಷ್ಟು ಮಾಡಿದ್ದಾರೆ? Income there is no dispute. What is that? Where is that discussion regarding income? Yes. where his total income is 1,12,000, so and so, his income tax returns assessment, so and so, where is profit and gain as business profit 2 lakhs. 2 lakhs. ಎರಡು ಒಂದು. ಎಷ್ಟಾಗಿದ್ದಾರೆ? 8,000 is correct average. ಎಷ್ಟು ಬರ್ತದೆ average ನಿಮ್ದು? No, if you show there is no loss of income, don't argue on that point. No, even if it is disability is 25%, because of disability there is no loss of income, then you are not entitled under that head. No, even if you taken 10,000, if there is no loss, then you are not entitled under that head. What is your answer for that? Suppose if a government servant, he suffered a 50% disability. If you continued in that service, he gets same salary, he is not entitled. Same principle here also. I thought, in this head you are not entitled. Then you will come to that. How many days you are in that hospital? 4 days. Yes, where is that chart? Pain and agony ಕೊಟ್ಟಿದ್ದಾರೆ. Incidental expenses 10,000, future medical expenses 10,000, loss of earning during the later period, loss of future earning, loss of 2009 they have given sufficient. Another one 30,000 will enhance and round up. Yes, 40,000. Yes, 40,000. Yes, global. It is the so-and-so learned council appearing for the claimant has contended that due to that extent, the claimant has suffered the following injury. He was inpatient for a period of 4 days. He has suffered lot of pain during the treatment. He has suffered this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. Hence, he sought for enhancement of compensation. For contra, Srimati Geeta Raj Learned Council appearing for the insurance company has contended that the injuries suffered by the claimants are minor in nature. He has not suffered any loss due to that injury. Considering that evidence of doctor and injury suffered by the claimant, the overall compensation awarded by the tribunal is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, Perose, judgment and award. It is not in dispute. The claimant has suffered an injury in a road traffic accident occurred on 5/1/2009 due to rash and negligent driving of rider of motorcycle bearing Atana, Bajaj Auto bearing registration number KA 146201. Due to the accident, the claimant has suffered the following injury. He was inpatient for a period of 4 days. He has suffered lot of pain during the treatment. Considering that evidence of doctor and injury suffered by the claimant, I am of opinion, in addition to that compensation awarded by the tribunal, 40,000 has been awarded with interest. Yes.
Next, we are Keshav Prashant.
Yes, Mr. Injury case. Yes, Mr. Mahesh. Pass on. Yes. Then appear for respondent number 4. Release this matter next week. Yes.
Serial number 44, for appellant.
43 is urgent, man.
No, 43, you are ready, Mahesh.
I am ready, my lord.
Pass on.
Please.
Pass on, Mr. Yes, he is ready. Pass on. 230. Dismissed.
Yes, Your Lordship.
Why?
Again,
Yes, there is no dispute. You are disputing that, then you will admit and call for the records.
Yes, Your Lord.
Yes. Admit. Call for records.
45, then Keshav Prashant for appellant. Serial
Yes.
number 45,
I-
then Keshav.
For the
Yes.
appellant in this case, my lord.
Yes.
Nobody represented on behalf of the respondents.
On what ground you are challenging, Mr.
It's about quantum, my lord.
The quantum.
Only quantum.
Yes. Or admit. Admit post for hearing on third November.
I have deposited the amount due of the stay granted by the Honorable Court, my lord, in 2019 itself. Our acknowledgement was not produced, madam. I will produce it in the next.
I will dispose it of since it is served unrepresented. Therefore, I am issuing the rule. Next time I will do.
46, R. Shashidhara for appellant. A. Ravi Shankar.
My lord, appearing for R2, my lord.
Yes.
Raise
Shashidhara.
thanks to me.
Yes, none appear for the appellant. Release this matter of 2 weeks.
Much obliged.
47, Manjunath ND for appellant. A. N. Krishnaswamy.
Yes, Mr. Krishnaswamy, ready? Ready na? Yes. Put it. Yes. 2016. Company appeal idea? Yes. Learned counsel for respondent submits that this appeal may be called along with that. Yes.
48, Nama Prasad for appellant. MP Srikanth.
Yes. Sham Prasad. RC1. On what ground, Mr. Policy. LMB. Transport vehicle. Is it covered? No, he is not there. Yes. None appear for the appellant, huh? Yes. Heard. Admit.
49, Kumar for appellant. Ravi Bendy.
49, not 49. Records may be necessary because he was fallen from Arekana tree anta bandide.
Alla yaru? You are appearing or Ravish Bini?
I have filed wakalat.
Yes. Office is directed to delete the name of Nodi. Name of Ravish Bini for R2. Yes. Office is directed to secure original records from the prisoner.
ಸೆಪ್ಟೆಂಬರ್ ಅಲ್ಲಿ ರವೀಶ್ ಬೆಣ್ಣೆ ಹಾಕಿದ್ರು, ಅಕ್ಟೋಬರ್ ಅಲ್ಲಿ ಅಗ್ರಿಮೆಂಟ್.
Both has filed an wakalat.
Or wakalat ಏನು ಗೊತ್ತಿಲ್ಲ, but I also filed wakalat.
Both has filed an wakalat.
Any of records may kindly be called, my lord, then we will sort it out.
Yes, let it be there. Improve the SVP. An office is directed to secure original records.
Okay.
50 adjourned. Number 51.
ನಿಮ್ಮ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿಯವರು ಅಲ್ಲೇನು ಒಂದು ಲೆಡ್ಜರ್ ಮೇಂಟೈನ್ ಮಾಡ್ಕೊಳಲ್ವಾ ಈ ಕೇಸಲ್ಲಿ ವಕಾಲತ್ ತಿಳಿ ಕೊಟ್ಟಿದೀವಿ ಏನು ಅಂತ?
Usually repeat ಆಗಲ್ಲ. I just have ascertained.
ಮತ್ತೆ ಇಬ್ಬರಿಗೂ ವಕಾಲತ್. No, why that wakalat has been given to two counsel? ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ಹೆಗ್ಡೆದು ಅವ್ರು ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಇವ್ರಿಗೂ ಕೊಟ್ಟಿದ್ದಾರೆ. Then now we have to decide who has to be appear next week. Yes.
ಅಲ್ಲ ರೆಕಾರ್ಡ್ಸ್ ಇನ್ ಹೆಸರಿ ಮಾಡಿ.
ಅದೇ ಕಾಲ್ ಫಾರ್ ರೆಕಾರ್ಡ್ಸ್ ಹೇಳಿದೀನಿ. ಸನ್ಮತಿ ಸನ್ಮತಿ ನನ್ನ appear will list this matter after 2 weeks. Number 53.
52, my lord.
Yes, Mr. Nagaraj.
Please, my lord, may I take your lordship's kind attention to the judgment page number 11, to the injuries.
No, that other side is third unrepresented.
The interest.
I will admit it.
Interest on kadime ಆಗ್ತದೆ ಅಷ್ಟೇ.
ಅದೇ, if you want to say that you have no case for dismissal, there is no objection.
Dismissal ಆದರೆ interest ಮಾತ್ರನೇ ಒಂದು ಇದು ಮಾಡಬಹುದು ಅಷ್ಟೇ.
ಅದಕ್ಕೆ then I have to admit it and I have to post for hearing. Since other side contesting respondent served unrepresented.
50,000 9% ಕೊಟ್ಟಿದ್ದಾರೆ ಸ್ವಾಮಿ.
I will fix the date. Yes. Post this matter on 27th.
Please.
Yes.
Number 53, Ananda Shetty A for appellant, A.N. Krishna Swami.
Yes, ready. Owner's appeal. Owner appeal. Why it is fixed on the owner? Ready? Yes, learned counsel for the appellant has submitted that all this matter along with the source.
Number 54,
Same, yes. Yes, all along with the source.
number 55, number 56, AJSN for appellant, P.G. Raju.
Yes, Tejas. Ready? Owner ಮೇಲೆ paper publication R1 Madhusri so place the ex party. Yes. On what ground it is ಏನ್ ಪೇ ಅಂಡ್ ರಿಕವರಿ ಆಗ್ಬೇಕಾ? Unauthorized passenger. Yes, pay and recovery. Pay and recovery ಇರ್ಬೇಕಲ್ಲ ಇದಕ್ಕೆ. ಮಾಡಿಲ್ಲ. Is it pay and recovery? ಅವರು ಓನರ್ ಲಯಬಿಲಿಟಿ ಅಂದ್ಮೇಲೆ ಫಿಕ್ಸ್ ಮಾಡಿದೆ. He has not appeared. He need not be necessary now. See, if ಎಲ್ಲಿ ಆಯ್ತು ಇಲ್ಲಿ ಲಯಬಿಲಿಟಿ ಅವ್ರ ಮೇಲೆ ಏನ್ ಶಿಫ್ಟ್ ಮಾಡ್ತಾ ಇಲ್ಲ. Pay and recovery ಮಾಡಿದ್ರೆ it is also granting a relief. He need not be a necessary part. He has, if he is not appeared, then we can pass it. Need not be posted for hearing. ಇಲ್ಲಿ our liability criminal liability ಅವ್ರ ಮೇಲೆ ಪಾಸ್ಪೋನ್ ಮಾಡಿರೋದ್ರಿಂದ he has not challenged, he has accepted. Suppose ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಮೇಲೆ ಮಾಡಿ ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಅಪೀಲ್ ಹಾಕಿದ್ರೆ ಅವಾಗ ಓನರ್ ನೋಟಿಸ್ ಆಗದೆ ಇದ್ದಿದ್ರೆ then notice has to be rule has to be it has to be admitted because now we are shifting the liability. Criminal is already held, that he has accepted, he has not challenged, then it is yes. You are not ready next week. ಅಲ್ಲೇನು ಮಾಡಿಲ್ಲ. ರೆಕಾರ್ಡ್ಸ್ ಬೇಕಾ? Yes, you are not arguing on that point. No, if you are arguing on that point, then I have to record that I have given a finding, then I require records. See, to change the finding, I have to see that records. Without records, I can't give. If you say that you are not disputing that, then for that I have to see that evidence and all. From where records has to come? Office is directed to secure original records for the prisoner. Post immediately after receipt of the record.
Number 57, AJSN for appellant, Anupama Agarwal, Ravi Samprati.
He wants time. Next week. You are the owner. You are not challenging that. Then when it is served? No, have you filed any appeal challenging that? Even today you have not filed, then you have accepted that award. No, madam, without challenging that, how can you argue now? Even after service of notice for this court also, you are not challenging. Even what has happened to that execution petition? I think what is the use without challenging that award? You have to complain. That is that responsibilities of that owner. When you are handing over that vehicle, that is your responsibility. You have to see that whether driver has a driving license or not. No, see that your negligence still, you are not challenging that order. No, without challenging, how can you raising all these grounds now? No, madam, I am giving a clue that you are not ready to challenge. You are not taking a clue from the court that are you going to challenge that award? You have to advise your client, madam. When he has come to you, should you not advise what he knows? That is why they are approaching that advocate to give an advice. You should have given advice immediately that you have to file an appeal or cross appeal. Nothing has been done. This has been from 2002 years already lapsed. What do you want? No, you are the Anupam Agarwal. No, who is Anupam Agarwal? I thought that you are in a new fresh council. You are not aware of that. Then your senior is there. She has to take a call when that appeal has to be filed. After 2 years, now I will decide on merit. Next week. Yes.
Number 58, for appellant, Janardhan Reddy.
Yes, Janardhan Reddy. Password. Where is?
Number 58, Janardhan Reddy.
Ready, Mr. Reddy. Yes. Where is that finding? 34. Karnataka Vidhan Sabha, he was drawing a salary of 29,000 per month in order to prove that employment income. This is petitioner has produced execution salary slip. This is that month salary 29,000. So, yes, Mister, how can you take that net salary? It is all settled law now. Yes, the Kodi salary slip Kodi. Income tax ಅಷ್ಟೇ ಮತ್ತೆ ಇನ್ನೇನು ಡಿಡಕ್ಟ್ ಮಾಡಕ್ ಬರಲ್ಲ. ಎಲ್ಲಿದೆ? 20 ಇದಕ್ಕೆ ಬತ್ತೆ ಆಯ್ತು, ಸಾರಿಗೆ ಬತ್ತೆ, ತುಟಿ ಬತ್ತೆ, ಈಗ ನಗರ ಸಾಮಾನ್ಯ ಬತ್ತೆ, ವೇದಿಕೆ ಬತ್ತೆ. ಡಿಡಕ್ಷನ್ ಎಲ್ಲಿದೆ? ಕಡಿತಗಳು ಈ ಕಡೆ ಇದೆ, ರೈಟ್ ಸೈಡ್ ಅಲ್ಲಿ ಇರೋದು. ತುಟಿ ತೆರಿಗೆ 200 ರೂಪಾಯಿ, ಎಲ್ಲಿದೆ 1100 ಅಲ್ಲಿಗೆ 1300 has to be deducted ಅಂದ್ರೆ 29,000 29,000 ಅಲ್ಲ 28,000 28,000 ಎಷ್ಟು 51 years. What is the deduction? ಮಾಡಿದಾರ ಕರೆಕ್ಟ್ ಆಗಿ ಎಲ್ಲಿದೆ ಏನ್ ಹೇಳಿದ್ದಾರೆ ಒನ್ ಥರ್ಡ್ 50% ಅಲ್ಲ ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಎಷ್ಟು ಬರುತ್ತೆ 51 years 15% ಅಲ್ಲ ಅದೇ ಅದೇ ಅಲ್ಲ 51 to 60 is 15. Yes, 15% ತಾಂಡಿದಾರಾ ಅಡಿಷನ್ 10% is added monthly income 10% ಮಾಡಿದ್ದಾರೆ 10% ಮಾಡಿದ್ದಾರೆ. It's not correct. 46 ಅಲ್ಲ 15%. The apex code made use clear addition of 10% added to the monthly income of the deceased is yes. Matale 10% of the yes. Anyhow, we will recalculate. Yes. Where is that? Petitioner is also entitled to proportionate interest rate 9% from the date of restoration of this petition. Allah, from the date of filing till the dismissal has to be given. Dismissal to restoration is not entitled. ಅದ್ರಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ಎಲ್ಲಿದೆ 50 not entitled for the interest from 26/9/2018 till date. Andre date of recalling. Yes. This has to be excluded. Yes. Interest for enhancement is 6%. ಬಾಕಿದೆಲ್ಲ ಕರೆಕ್ಟ್ ಇದೆಯಲ್ಲ ಎಸ್ ಶ್ರೀ ಗೋಪಾಲ್ ಕೃಷ್ಣ ಎನ್ Senate Council appearing for Senate has contended that at the time of the accident deceased was aged about 51 years. He was working as an undersecretary to the government of Karnataka and was drawing sum of rupees 29,300. To that effect, he has produced the salary slip. The tribunal has error in considering the monthly income of the claimant as only 18,000 per month. He further contended that the tribunal is error in not granting any interest from the date of filing the petition, from the date of restoration of the petition for dismissal for default. Hence, he sought for allowing that appeal. For contra, Sri Reddy Learned Council appearing for the insurance company has contended that The tribunal, after considering that salary slip, after deducting, considering the salary slip, has taken net salary of the petitioner as 18,000 and has rightly assessed the monthly income of the deceased as 18,000 per month. He further contended that considering that age and avocation of the deceased, the overall compensation awarded by the tribunal is just and reasonable. Lastly, he has contended that the interest awarded by the tribunal 9% is on higher side. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties, arose judgment and award. It is not in dispute. Anil Kumar TR Gangadhar died in road traffic accident occurred on 21/3/2011 due to rash and negligent driving of driver of bus bearing registration number KA01 FA 2356. At the time of the accident, the deceased was aged about 51 years. He was working as Undersecretary to the government of Karnataka and he was drawing salary of rupees 29,300. To that effect, he has produced salary slip as Exhibit P11. As per that Exhibit P11, he was drawing salary of rupees 2,900, 29,300, out of which 200 rupees has to be deducted for professional tax and 1,100 rupees has to be deducted for income tax. The monthly income of the claimant deceased has to be assessed as 28,000. Accordingly, the monthly income of the deceased has been assessed as 28,000 per month. In view of judgment of apex court in case of Pranay Sethi, 15% of the income of the deceased has to be added for future prospects. At the time of the accident, he was aged about 51 years. The multiplier applicable to the age group is 11. Accordingly, loss of dependency has been reassessed already. Since there are two dependents, 1/3 of the income of the deceased has to be deducted for personal expense. Accordingly, loss of dependency has been reassessed as follows.
32,200 minus 10,733 at the rate of 1/3, 21,467. 21,467 into 12 into 11, 28 lakhs 33,644.
In addition, 15,000 for loss of estate, 15,000 for criminal expenses. In view of judgment of apex court in case of Nagma, the claimants are entitled. First claimant is entitled 40,000 for spousal consortium. The claimant number 2 is entitled 40,000 for parental consortium. The claimant is entitled interest. In respect of interest is concerned, the claimant is entitled interest from the date of filing the claim petition. The claimant is entitled 9% interest in respect of 19 lakhs 32,000, excluding the period of from 26/9/2018 to 21 February 2018. The enhanced compensation amount carries 6% interest. For 19 lakhs 32,000, 9% interest excluding that period. For enhanced compensation, 6%. In view of order dated 25/5/2022, the claimant is not entitled for the interest for enhanced compensation amount for a period of 168 days.
Page
My lord, in this case, my lord, kindly after 2 weeks, my lord, the copy is just I will check it up whether.
Yes, Mr. He has sent the. No, he is not ready.
Pardon, my lord.
No, he said he has sent that copy through WhatsApp.
Just I'll check it up and my lord after kindly be called after 2 weeks, my lord. Sorry, my lord.
Yes, at the request of counsel for respondent number 2 as a last chance, release this matter of 2 weeks.
Problem.
Connected matter, Purti Agregan.
Yes, madam, what is this? Yes. Single bench, da? Yes, that is the only ground. $4,500 ಅಂತಂದ್ರೆ what is that date of accident? ಎಲ್ಲಿದೆ? $27 D. Petitioner producing the records of rights so and so, wherein column number 9 name of the deceased for the petitioner of not per month. And agricultural land by doing the agriculture work, the so and so, 63. He was 5 of that, the father was 63 years old, when she looking to the age and extent of the land. For an agriculture, it is to live for. Allah, that is the only income they have taken. Allega 17,000 plus 4. 22,000 sand is there. No, that he has an agriculture land. Allah, income Allah. By some extent, there is a loss of supervising that property. Is it not? ನೋಡ್ಕೊಳೋದು ಒಂದೇ ಅಲ್ಲ. See, when he is there, he is also doing some work, and that now that has to be compensated by other labor. Some extent, yes. See, ನೀವು 5 ಜನ ಮನೇಲಿ ಇದ್ರೆ, they will not engage that other labor. They will do their own work. If one person is no, what is that? Where is that records? See what they are growing in their evidence. Have they said if they are cultivating and they are doing? Where is records? RTC records ilva? Records ಬಂದಿಲ್ವಾ ಅದು? You have that RTC. Then we'll next week we'll put up that records. We'll see what is that RTC ತೋರಿಸಿರ್ತಾರೆ ಏನ್ ಬೆಳೆ ಅಂತ. Why you are not available before that? Yes. Yes, release this matter on 27th. Office is directed to put up the record. Yes, Mr. What is this thing? It is better. I will recall it and post before the. No. That is on merit. See, their case is that. They say that their admission is only saying that committee will take a decision within reasonable time. It is not. No. The direction in that order is that they say that. No, you are saying that can be modified. Saying that let the committee take it. Then it's that's all. Committee can be that can be modified to saying that if the committee has to be taken undertake that will take a decision within 3 months. Yes, that will be modified. You take whatever decision you want. Then it is fair. That is what that senior counsel. Where is that? Yes, on Tuesday. No, Tuesday. No, Tuesday will say that. I think, see, now either way committee has to take any decision. Now we said that committee has to frame the rules. Now they are saying that committee has to take any decision within reasonable time. You take whatever decision. Yes, Tuesday. You ask that Sriranga to be appear on Tuesday. Yes. That is what they are stated in the memo also. Yes. Why, madam, you are appearing for? Punacha, you are appearing for R3. Is there any dispute regarding the liability? Then their presence. Rammoorthi ne illalla. It is 2011 matters. Pass over. Our regular council, MEC, I have not seen them. What to do next week? You just contact him. Monday, Tuesday. Yes, you have no role, madam. Why do you want to take the time? Unnecessary. Yes. Yes, Mr. Ravi Shankar.
63, here Ravi Shankar for appellate. Matter.
What is this? Engine mudguard. Body. No, our judgment is that on the mudguard in the engine. What is that policy? They have taken any? Have they taken any additional premium for? Where is he? All admit agi idಕ್ಕೆ ಬಂದಿದ್ಯಲ್ಲ. Where is Chetan? Next week. Yes. None appear for responding. Release this matter of 2 weeks. Other old matter. Either way, we'll decide it. Yes, let us see what he will say that. When do you want? No, it is pass or let us see if he comes afternoon. Yes, next week.
Serial number 64 urgent, serial number 65, B.P. Raju for appellant, connected matter, K.T. Gurudeva Prasad.
Yes. Ready? Yes, mister. Hmm. 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 What is the date of tax then? 29/6/2009. When you have communicated for once judgment idea Supreme Court judgment. There again. No, is it communicated to him? That is what the Supreme Court said. That is what that, yes. No, is it the case where Supreme Court has decided? There was no such condition in that policy. No, you are for an yes. No, you are appearing for the claimants or an owner? Claimants. Ultimately, it is a pain recovery. Insurance liability against the third party is extent of when the check issued for the payment of premium was dishonored. Subsequent to the accident, one should transfer the policy of the insurance in such a circumstance, natural liability of the insurance party, which policy covers subsistence insurer has. Yes. R5 ಆದ್ಮೇಲೆ ಎರಡನೇ ಶೀಟ್ ಶೆಡ್ಯೂಲ್ಡ್ ಆಫ್ ಪ್ರೀಮಿಯಂ. In case of
case of dishonor, the company shall not be liable under the policy, and the policy shall be void if it should go. Inception just now, like inception, go to cancel. Cancellation, not a. So I have. So you are not going to be regarding the country because of you are. They go to the decision and you are running. So when they make money like that, one has to prove the existing policy. Imagine this circular includes
Yes, this condition was not there in that earlier. Yes. Then now why you are giving a notice then? It automatically it is cancelled. Alalala, if this class is not there, until that contract has to be cancelled, it has been existence. Here, with one wide abeyance, is it necessary for giving in a notice now? Yes. See, that is secondary. What you say about that pain recovery? Alala, it will not make any difference. Even including this condition, if you pay and recovery is there, ultimately Supreme Court said you recover from that owner. In that case also. Alala, that's what I am asking. Even if this condition is there, what you say about the pain recovery? No. I'm not on the Flexamama case. After subsequent judgment in all aspects regarding the pain recovery, policy Tashna. Yes. The policy itself is not there. Yes. Yes, notwithstanding anything. Yes. Issued by a person who is authorized insurer persons against the death, notwithstanding anything contained in the Yes. Yes. 147(4).
or the rules made thereunder not followed by a policy of insurance within the prescribed time, the insurer shall within 7 days of the expiry of the period of validity of the cover policy notify the fact that the registering authority in whose regards the vehicle to build the government relates has been registered or to procedural authority and the state government to prescribe the authority. Lowering permit.
So there should be an entry in that RTO.
They are not using this government game.
See, what is the intention of the legislation? You have to intimate to that RTO is that. Yes.
Production of certificate of insurance application for authority to use vehicle. The person has an authority to use the vehicle provided the certificate of insurance. Nobody can. The vehicle owner have no right. That is the mandate of 146.
Yes.
The state government may make rules requiring the owner of the motor vehicle then applying to that a payment of tax or otherwise of authority to use the vehicle in a public place to produce such evidence as may be prepared by those rules to effect that either on the date when the authority to use the vehicle comes into operation, there will be for necessary policy of insurance in relation to the use of the vehicle by the applicant or by other persons on his order or with his permission. Except the 146(2) KSRTC only one exemption. Either allowed to use the vehicle or produce it. They have no authority to use. Policy of insurance. Policy in the whole. Payment would not arrive. Policy conditions why they do not get a there is a policy of insurance scheme. Anybody act the word of the there will be more relationship and more things. Is it not complete? Yes, there will be a part. Immediately, but can't expect me to suffer a loss.
Yes, Mr. No, that now that you have to see on the Contract Act also, by putting a condition itself in that contract, will it be automatically cancelled without giving any notice on that ground?
There is no consideration not passed. There is no policy.
No, that's what that. See, will it be cancelled automatically? If the contract.
central government authority, DRDO, control this, you would give a direction. Policy administrative becomes fine. Policy itself becomes a issue. Therefore, option of subsequent cancellation number one.
One more point is that, is it not required to give a notice that in view of that, see, he has to aware that whether my check has been bounced. Yes.
Cancellation one. Agreement is avoided cancel.
Alala, that's what I am asking. That, yes. It has to be on the Contract Act. Yeah, that which is that. No. What I want to see, whether any judgment which is passed on that policy which has this such a condition. Reserved on same point. Allah, but judgment has not come out. But it is reserved for on this point, very same point. Let us see, we will wait. But in the meantime, this point is also, we'll see. Adi nimde yavada judgment? Adralli no, what is that point you are canvassing? No, where that policy which has such a condition, is it necessary? Now we have to see under the. No, now that, see, now we have to go to the General Act, that is a Contract Act. Under the Contract Act, if such a condition is there between the two parties, is it necessary for him to give a notice for cancellation? Other melgade, you have to just search the judgment. See, contract madkondaga, if you not paid this amount within 15 days, contract will cancel at the void and tiddaga. Is it necessary for cancellation, or he has to go to the court for cancellation? On that, you have to search in a judgment. No, he has a part of the contract. See, is it, see, even though such a condition, whether notice is required, you can see under that Contract Act, you will get that judgment. Not another point. Let us see on that judgment, and also in the meantime, let us see what is that outcome of that other judgment also. Adralli, who is that counsel who has appeared in that other side? For yes, let us. No, that I will come to that pay and recovery later. I will come to that less. That will also discuss. When he has raised this point. ಆಮೇಲೆ next interest of the claimants will come to later whether pay and recovery is there or not.
Both the policies be able to find simple.
No, that, yes, yes. One or appear ಆಗಿದ್ದಾರಾ? Yes, owner is there. And you also canvas on that second point, even if that Gurudev Prasad and pay and recovery also, if pay and recovery, if you convince that, then we need not go to that point, because ultimately, even earlier case also, even if there is no notice has been issued, then still the right of that insurer is there to recover from the insured. Yes, that is true. Now, if there is no any Supreme Court judgment, then
There is a judgment question at the same point.
Huh?
They want to take consideration to the Supreme Court judgment. Otherwise, all other decisions rendered by Supreme Court law.
ಯಾವ್ದದು? Now, what is the date of the accident in that case? See, now we have to see Supreme Court judgment relay ಮಾಡಿದಾಗ ಅದರಲ್ಲಿ what is the condition of the policy ನೋಡಬೇಕು. If similar condition is there, Supreme Court has allowed, then I have not, it's ಅದನ್ನ you have to examine any cases arising out of from our state, then you can see that policy. ಇದು ಹಳೆ ಕೇಸು, ರೀಸೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಗಳು ಯಾವ್ದಾರ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಆಗಿದ್ರೆ, then you see it is from our high court, then you can find out that policy condition. Yes, let us see. I will also verify that and we'll see what is some other. Kara? Yeah, therefore is the position despite the bar created a 6 for the insurance, the appellant and authorized insurer issued and policy of insurance coverage was without receiving the premium for any reason. It become liable to indemnify the third party in respect liability which says the policy cover and satisfy the award of the company. Authorized the issued a policy of the insurance to cover the bus without receiving the premium thereafter. Providing the persons liable to eliminate third parties. Now that class is, the policy itself is cancelled. That is that. I understood. No, now that this can be answered on more. And what is that?
Last week.
In the meantime, we verify. Let us see that if the matter has been seized by other court, we'll wait. If they have answered this question, we need not. Otherwise, we'll consider this fine. Also verify under the contract act. What is the time? I think we have to go for the contract act only. Yes. Which is that number which has been resolved by that? Yes. Very same point has been canvassed. Yes. Next week. Let us see in that.
Of receipt of premium regularly.
Serial number 72, my lord.
Wait. This statement I will, let us see, I will also go through it.
Serial number 72, my lord. Serial number 72.
Yes, what is this, Mr. Krishna?
Kindly be on Monday, my lord. Kindly be on Monday.
Wait. Still I'm on the list. Yes.
Hello, file, my lord, by mistake, my lord. Narayana was filed that, sir.
Wait, it not as over, Mr.
67 call out ಆಗಿದೆ sir. ಒಂದು ನಿಮಿಷ.
Yes, what is this, Mr. Krishna? Who is that Pradeep? Pass out 230. 67. 66 ಏನಾಯ್ತು? Yes. 67. Yes, you want time? Yes. Release this matter next week.
N. Krishnaswamy for appellant. Dilip Kumar, T. Nataraju.
Yes, what is this matter? Yes. What is that matter, Mr.? On what ground you have challenged that? Yes, we'll do it. Yes, Mr. Where are you? You are not been seen last 2 days. Ready? Alala, why I have passed over this? Can I condone the delay without interest? Yes, that's what that passed over. I will call for records. Instead of that, again posting for an IA. Then 230. Both of them. I bunny 230.
$72, my lord. 72, my lord.
Yes, Mr. Hegde. 72, what you want?
Called on Monday, my lord.
72. The request of counsel for respondent. Appellant. Release this matter next week. 71. Yes. You are appearing for owner or a claimant? Yes. Why you want time, madam? 2011 matters. When do you want? Saturday working day. You will have it on Monday. Monday. Yes.
Court officer. Court officer. Court officer.
ಸರ್ ಹೇಳಿ
ಸರ್ 70
ಹೇಳಿ.
ಅರ್ಜೆಂಟ್ ಆಗಿದೆಯಾ ಇದೆಯಾ ಸರ್?
78 ಜನ ಆಯ್ತಲ್ಲ ಸರ್ 2 weeks.
ಹೌದಾ?
ಬೆಳಗ್ಗೆನೇ ಆಗಿದೆ. ಹಾ
ಅಯ್ಯೋ ಸರಿ ಸರ್, ಥ್ಯಾಂಕ್ ಯು ಸರ್, ಥ್ಯಾಂಕ್ ಯು.
ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀವಿ.
Court officer है court officer court officer court officer
ಯಾವ ಲಿಸ್ಟು? ವಿಚ್ ಟೈಮ್? ಟೈಮ್ ಪ್ರಕಾರ ನಿಮ್ಮ ಆಫೀಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಯಾವ ಟೈಮ್ ಅಲ್ಲಿ ಇದೆ ಅದು. 4th ಟೈಮ್ 2 weeks. ಹಾ ಏನು ಬರ್ತಾರಲ್ಲ ಈಗ ಶನಿವಾರ ಇಲ್ವಾ? ಸರಿ ಅವತ್ತೇನು ಇವತ್ತು ಅಂತ ಅವ್ರು ಹೌದು ಅದಷ್ಟು ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಯಾರು? ಅಲ್ಲ ಫುಲ್ ಏನ್ ಬೇಡ, ಫುಲ್ಲು ಅವ್ರಿಗೆ ಅಷ್ಟೇ. ಅದೇನಲ್ಲ ಅಡ್ಜರ್ನ್ಮೆಂಟ್. ಸಾಹೇಬ್ರೇನಾದ್ರು ಕೇಳಿದ್ರು ಇನ್ ಕತೆ. LCR ಒಲ್ಸ್ಕೊಳ್ಳಿ ಮೇಡಮ್ ಬರ್ತಾರೆ.
Serial number? memo for dispensation for R1. Note delay of 15 days is controlled. List this matter on Tuesday.
Matter. Serial number 2, M. Chaudhary Raji for appellant, N. S. Harish Kumar. This is taken to inspection.
ಅಲ್ಲ ಸೀರಿಯಲ್ ನಂಬರ್ 2 ನಾ ನೀವ್ ಯಾರಿಗಿದ್ದೀರಾ? ಹೌದು ನಿಮ್ದು. Furnish. I think you have to take 3 times and you file in this. Yes. 2 weeks time is granted to do the needful. Yes.
Number 32.
ನಾನ್ ಕಂಪ್ಯೂಟರ್ ಮೇಲೆ ಹೋಗ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಒಂದ್ ಹಿಂಗೆ ಓಪನ್ ಮಾಡಿ ನೋಡಿದೆ. ಓಪನ್ ಮಾಡಿದ ತಕ್ಷಣ ಕೇರಳ ಹೈಕೋರ್ಟ್ ಫುಲ್ ಬೆಂಚ್ ವೇರ್ ದಟ್ ಚೆಕ್ ಹ್ಯಾಸ್ ಬೌನ್ಸ್ಡ್, ಪಾಲಿಸಿ ಹ್ಯಾಸ್ ಬಿನ್ ಕ್ಯಾನ್ಸಲ್ಡ್. It has been intimated to that owner and also intimated to that RTO. After that accident has been occurred, they said that to pay and recovery. Allah, intimation, cancellation, all admele accident agide. Still they said that pay and recovery. Same principle. Pay and recovery, I think, ಬೇಕಾದಷ್ಟು ಜಡ್ಜ್ಮೆಂಟ್ ಇದಾವೆ. ನಾ ಸುಮ್ಮನೆ ಹೋಗ್ಬಿಟ್ಟು ಹಿಂಗೆ ಹಾಕಿದ ತಕ್ಷಣ ಜಡ್ಜ್ಮೆಂಟ್ ಸಿಗ್ತದೆ ಅಂತ ಹೇಳಿ. You can say full bench. Matter has been referred to the full bench. They said that pay and recovery, they have taken a concept. Policy has been issued for 1 year. Even though it is cancelled, you recover from the owner, but pay for an full bench decision. ಕೊಡಿ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಸುಮ್ಮನೆ ಹಿಂಗೆ ಹಾಕಿದ ತಕ್ಷಣ ನೋಡಿದ್ರೆ ಜಡ್ಜ್ಮೆಂಟ್ ಹುಡುಗಿದ್ರೆ ಸಿಗ್ತಾವೆ. ಈಗ ಆಲ್ಮೋಸ್ಟ್ ಆಲ್ ಪಾಯಿಂಟ್ಸ್ ಯು ಕ್ಯಾನ್ ಗೆಟ್ ಇಟ್. ಇದು ಸೆಂಟ್ರಲ್ ಆಕ್ಟ್ ಅಲ್ಲಿ ಬೇಕಾ ಎಲ್ಲಾ ಸ್ಟೇಟ್ ಅಲ್ಲೂ ಇರ್ತಾವಲ್ಲ, ಯಾವ್ದಾರಲ್ಲ ಒಂದ್ ಕಡೆ ಡಿಸೈಡ್ ಆಗಿ. Yes, what is this matter? Yes. Yes. Where is that finding? Yes. Yes. No, that immediately complaint has been lodged. Yes. No, that first instance it has been reported that it is an accident. Number has not been mentioned. Like MLC extract, what is the date of the accident? Until 5/2018. 6/6/2018. Yes. What is that? Which is that? Para 13, Vadi. It is true that No, FIR and complaint has been, the FIR has been registered against the KA 53. Complaint is also, yes. Then charge sheet has been filed. But investigation officer is not examined. How he has come to the conclusion that, yes, that is the only. Then you have to, doctor has to be examined. Yes, but 2 points, you have also not examined any witnesses. Right. It is not their case of the claimant that they are collided. Yes, that's. See, Surya Prasad, Learned Counsel appearing for the claimant has contended that the claimant has suffered an injury in the road traffic accident occurred on 17/5/2018 due to rash and negligent driving of driver of the car bearing registration number KA53C5585. Immediately after the accident, the petitioner has lost conscious. He was not in the position to identify the car number. When he has been admitted to the hospital, in the first instance, he has given a statement before the doctor that his vehicle has been hit by the car. Same has been written in hospital records that has been produced as P16. The tribunal has failed to consider this aspect of the matter. He further contended that after that claimant has recovered from the injury, he has lodged in a complaint. The police, after investigation, has filed a charge sheet against that offending vehicle. The same has not been disputed by the owner or the driver of the offending vehicle. The tribunal, without considering this aspect of the matter, the error in dismissing the claim petition, hence he sought for allowing that appeal. For contra, Sri Sanmati Learned Counsel appearing for the claimant insurance company has contended that the accident is occurred on 17/5/2018. The complaint has been lodged on 26/6/2018. After delay of 39 days, the claimant has not given any proper reason for delay in lodging the complaint. He further contended that even though the police has filed a charge sheet against that offending vehicle, driver of the offending vehicle, the investigation officer has not been examined to prove that how they have obtained that information regarding that offending vehicle. The tribunal, after considering that evidence on record, has rightly dismissed the claim petition. Heard the Learned Counsel for the parties arose judgment and award. The case of the petitioner that on 17/5/2018 at about 5:30 a.m. when he was riding his motorcycle bearing registration number A01 HT 4708 on Ring Road near Lumini Garden, Bangalore City. The driver of the car bearing registration number KA53C5585 driven in rash and negligent manner dashed against the petitioner motorcycle from behind, caused an accident. Due to impact, he fell down and sustained injury. Immediately, he was shifted to MS Ramaya Hospital. After recovering from the injury, he has filed a claim petition. The claim petitioner has been examined himself as PW1 and produced 18 documents. The specific case of the claim is that Immediately after the accident, he lost conscious. He was not in the position to identify the registration number of the car. But the moment he has been admitted to the hospital, he has given a statement that his vehicle has been hit by the car. The same has been made in an entry in the MLC extract 2006, MLC extract produced as Exhibit P16. It is registered on 17/5/2018, same data, 17/5/2018. Even the police has filed a charge sheet against that offending vehicle bearing registration number KA53C5585. The tribunal has failed to consider the said documents. The respondent, the petitioner, has failed to examine the doctor who has written that MLC, which is produced as Exhibit P16, and the parties has not examined the investigation officer to prove, to establish that the vehicle bearing number KA53C5585 was not involved in the accident. Under these circumstances, to give one more opportunity to both the parties, the matter requires to be remitted back to the tribunal for first consideration. Accordingly, the appeal is allowed. Judgment and award passed by the tribunal is set aside. The MEC number 4546 of 2018, 2018 is restored. The tribunal is directed to reconsider that matter afresh after giving an opportunity to both the parties to adduce evidence and produce additional documents. The tribunal is directed to decide that matter without influencing any observation made by this court in this order. The parties are directed to appear before the tribunal on 9th November without any further notice. The tribunal is directed to dispose of the matter within 4 months from date of present of the parties, appearance of the parties. Yes, IA delay of 256 days condoned. IA is allowed. Yes. Learned counsel for the appellant has filed a memo seeking dispensation of notice to R2. Memo is taken on record. Notice to R2 is dispensed.
Number 34, Antaraj K for appellant, Kishore Kumar Reddy.
Who is Kishore Kumar Reddy? Oh, she used to come. Monday. Yes. None appear for rest. Yes. Records bandidya? Is it there? Records beka? Yes. That is the only point. Yes. What is the date of the accident? 2018. 18 ಅಂತ ಅಂದ್ರು 12,500 ಇದೆ. You have that evidence. What are the injuries? Compound fracture both bones of the right leg. He has to so he has been shown. And doctor, each component's disability ಏನು ಹೇಳಿಲ್ಲ. Yes, 30%, 10%. What is his age? 34 years. What is that other head? ಡಾಕ್ಟರ್ ಹೇಳಿದ್ದಾರಾ ಇದ್ಮೇಲೆ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ವೆರಿ ದಟ್ patient has right leg approximately cost of he has undergone surgery. Yes. Well, the Contract Learned Council appearing for the claimant has contended that at the time of the accident, the claimant was earning 15,000 per month. The tribunal has assessed the notional income of the claimant as 7,000 is on lawyer side. He further contended that due to that accident, the claimant has suffered grievous injury. He has examined the doctor. Doctor has assessed a functional disability of 30%. The tribunal has assessed whole body disabilities 10% is on lawyer side. Lastly, he has contended that the injury suffered by the claimants due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lawyer side. And he further contended that the claimant required 50,000 rupees for removal of the implants. The tribunal has not granted any compensation under the head. Hence, he sought for enhancement of compensation. Per contra, so-and-so Learned Council appearing for insurance company has contended that even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. In the circumstances, the tribunal has rightly assessed the notional income of the claimant as 7,000 per month. He further contended that even though doctor has assessed the permanent disabilities is 30%, he has not assessed the limb disability. Therefore, the tribunal, after considering the evidence of the doctor and injury suffered by the claimant, has rightly assessed the whole body disabilities 10%. Lastly, he has contended that considering that evidence of doctor and injury suffered by the claimant, the compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is just and reasonable. Hence, he sought for dismissal of the appeal. Heard the Learned Council for the parties, arose judgment and award. It is not in dispute the claimant has suffered an injury in a road traffic accident occurred on 4/4/2018 due to rash and negligent driving of driver of car bearing registration number KA41 Z0599. Due to that accident, the claimant has suffered the following injury. He has examined the Dr. Nitin as orthopedic surgeon as PW2. In his deposition, he has deposed that the petitioner has suffered from permanent disability at 30%. Considering that evidence of doctor and injury suffered by the claimant, the tribunal is justifying assessing the whole body disabilities 10%. Even though the claimant has claimed that he was earning 15,000 per month, he has not produced any document to establish the same. In the circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring 2018, the notional income has to be considered as 12,500. At the time of the accident, he was aged about 34 years. The multiplier applicable to the age group is 16. 16. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for pain and suffering from 15,000 to 50,000. Loss of immunities from 5,000 to 40,000. Loss of income during the later period for 3 months. Due to the accident, the claimant has suffered an injury. He has undergone surgery. He has examined the doctor as PW2. In his evidence, he has deposed that the claimant is required. Claimant has to undergone surgery for removal of the implant. It may cost about 50,000 rupees. Considering the evidence of the doctor and injury suffered by the claimant, I am of the opinion that the claimant is required 25,000 rupees for future medical expenses. Thus, future medical expenses will not carry any interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. Yes, Mahesh, what is this? Yes. Yes. Yeah. How much? What is the percentage? Where is that finding? So number 1. How the accident has occurred? Near that Nagudi village and village for petitioner of procedural units pick up when bearing registration. First respondent alleged to have driven his LMC Tata motor vehicle bearing registration from Davangere. So ಆಯ್ತು ನೀವು ಪಿಕಪ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ರಿ ಆಯ್ತು ಪಿಕಪ್ ಈಸ್ ಆಲ್ಸೋ ನೆಗ್ಲಿಜೆಂಟ್ ಅಂತ ಹೇಳಿದಾರ ಮತ್ತೆ ಅದಕ್ಕೆ ಇನ್ಸೂರೆನ್ಸ್ ಇಲ್ವಾ ಮತ್ತೆ ಯು ಕ್ಯಾನ್ ಕ್ಲೈಮ್ ಅಗೇನ್ಸ್ಟ್ ದೆಮ್ why are you worried that he's you are in a climate and the giant thought feature that the insurance company has to pay and recover from them? Why you are challenging that? When that he himself was not challenging, why you are challenging that? ಅದ್ರಲ್ಲಿ ಇನ್ನೊಂದು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಇದೆಯಾ ಯಾರು ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡ್ತಾ ಇದಾರೆ ಎಸ್ ಮಿಸ್ಟರ್ ಕೇಶವ್ ಪ್ರಶಾಂತ್ he has not filed any appeal and challenging then what is to worry about only where is that Ada Barkin. No, you will see what is that award. The petitioner is held to entitled to 7 lakhs rupees, 7% interest. Respondent 1 are hereby 1 to 4 held jointly and severally liable to compensate the petitioner. 1 to 4. 1, 2, 3. ಎರಡು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿಗೂ ಹಾಕಿದಾರಲ್ಲ ಮತ್ತೆ ನೀವು jointly and severally liable 75-25%. Yes, why are you arguing that? I will come to that. What is the date of the accident? 21/5. Yes. $3,500. 2080 ಗೆ 4,500 ಇದೆ.
My lord, may I make one submission?
Yes, yes.
My lord, I have misplaced my file. One short accommodation will be given, my lord. I don't know the facts of this case, my lord.
No, ಮಹೇಶ್ ಇದಾರೆ. ನಿಮ್ಮ ಮೇಲೆ ಬರೀ 25%, ಮಹೇಶ್ 75%. Mahesh has more responsibilities than you.
ಆಯ್ತು sir. If everything is clear, my lord, I have no issues because I don't.
ಅದೇ 75-25 ಮಾಡಿದ್ದಾರೆ. I think 75 is for your insurance company, Mahesh. Is it, Mr. Mahesh?
No, I too don't have the papers, my lord.
Oh. Now that 100% is ಆಯ್ತಲ್ಲ.
And it is not available on the website also, my lord. I tried to get it on the
No,
website.
let us see that what will be that enhancement. If it is more, then I will give an opportunity. Let
Yes.
us see that. Let him argue first. Yes.
Please.
On the grounds of appeal, my lord, it is found that it is a negligence of 25% to 75%.
ಅದೇ 25% ಯಾವ ವೆಹಿಕಲ್ ಮೇಲೆ
Injured vehicle. It is, my lord, injured.
ಅಪಲೆಂಟ್ ಯಾವ್ದು ನಿಮ್ದು ವೆಹಿಕಲ್? ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾವ್ದ್ರಿ? ನೀವು ಟಾಟಾ ಪಿಕಪ್ ಅಲ್ಲಿ ಹೋಗ್ತಾ ಇದ್ರಲ್ಲ, ಪಿಕಪ್ ಗೆ ಯಾವ್ದು ಇನ್ಸೂರೆನ್ಸ್ ಕಂಪನಿ? ಇಕೋ ಟೋಕಿಯೋನೋ ಅಥವಾ ಇದಾ? ನಾನೇ ನೋಡ್ತೀನಿ ಬಿಡ.
Lord, he was driving a vehicle bearing, my lord, 6745.
Yes. No, that you are insured with which vehicle, Mr. Mahesh?
No, that I can't be able to make out, my lord, because
Yes. No. Yes, I will find it. Yes. Part of that freedom as well as the first responded towards the cause of the action means that negligence can be approximated to 25-75.
In this case, my lord, I was directed to take notice.
Yes.
Bag ನಾನು ವಕಾಲತ್ತು ಹಾಕಕ್ಕೂ ಆಗಿಲ್ಲ. I have not received the copy of the.
Let us see. Wait. Work was not shown. So, ಯಾರ ಮೇಲೆ 25 ಅಪ್ಪ?
on the claimant, my lord, Sangamesh. He was, my lord, driving the pickup van bearing registration number KA17A 6745.
Oh, Sangamesh.
Other vehicle is Tata Mobile KA22N1161.
No, he himself was driving that vehicle.
Yeah, himself was driving the vehicle.
For him, it is 75%.
And the insurer, my lord, which company is not forthcoming, my lord? Which vehicle was insured with which things?
75% ಯಾರಿಗೆ? ನಿಮ್ದು ವೆಹಿಕಲ್ ಯಾವ್ದು? ನಿಮ್ದು ಇನ್ಶೂರೆನ್ಸ್ ಕಂಪನಿ ಯಾವ್ದು? Cholamandala is 25%.
Cholamandala, most probably, my lord, Mahesh sir is appearing on.
Yes. Ifco Tokyo is this thing.
75%.
75%. Then 25% that it is a comprehensive insurance policy. Then insurance company is liable. You are not liable. Then only that this thing. What is that negligence? The percentage of disability?
But bad answer this one because I don't have any papers. I was directed to take notice. Then a copy no receive. That's why I have not filed the wakalat.
Tribunal has directed that respondent number 1 to 4 are held jointly and severally liable to the compensation. The third and fourth respondent are held liable to that 75-25. Third is manager of Ifco Tokyo, that is 75. And manager of Cholamandala is 25%. That is clear in that tribunal order.
But he has suffered, my lord, I think total award is 7,11,200.
Yes.
40,000 pain and suffering,
Yes, that is correct.
5 lakhs medical expenses, 10,000 laid up period income, and future earning capacity 1,51,000. Loss of immunity is 10,000.
Now, only if I see that, is there any disabilities has been correctly assessed or not?
Yeah, date of accident is 2008.
No, doctor has assessed that limb disability is 90%. 1/3 ಅಂತಂದ್ರೆ 23 30 ಆಗುತ್ತೆ ಅಷ್ಟೇ, 10% ಜಾಸ್ತಿ ಆಗುತ್ತೆ. 30% ಆಗ್ಬೇಕು. ಆಯ್ತು, 3 ತಿಂಗಳದ ಇದು ಅಷ್ಟೇ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಎಸ್ ಮಿಸ್ಟರ್ ಮಹೇಶ್?
Yes, madam.
Now the tribunal has taken that disabilities is 20%. It should be 30%. 10% has to be enhanced. Income has to be taken by 3,500. It should be 4,500. 3-month later period. That's all.
Okay.
Have you undergone surgery? ಯಾವಾಗ? ಅಲ್ರಿ ಈಗ ಆದ್ಮೇಲೆ 5 ಲಕ್ಷ ರೂಪಾಯಿ ಕೊಟ್ಟಿದಾರಲ್ಲಪ್ಪ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್. ಅಂದ್ರೆ ಹೇಳೋದು ಫ್ಯೂಚರ್ ಮೆಡಿಕಲ್ ಎಕ್ಸ್ಪೆನ್ಸಸ್ ಟ್ರಿಬ್ಯುನಲ್ ತೀರ್ಮಾನ ಆಗಿದೆ ಯಾವಾಗ ಹೇಳಿ? 2012. ನೀವೀಗ ಆಪರೇಷನ್ ಮಾಡಿಸ್ಕೊಂಡಿದ್ದೀರಾ 12 ವರ್ಷ. ವೇರ್ ಇಸ್ ದಟ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ಮತ್ತೆ ಡಾಕ್ಟ್ರು ಹೇಳಿದ್ರಿ, ಆಯ್ತ್ರಿ, ಡಾಕ್ಟ್ರು ಹೇಳಿದ್ರು 12 ವರ್ಷ ಆದ್ರೂ ನೀವು ಆಪರೇಷನ್ ಆಗಿಲ್ಲ ಅಂತಂದ್ರೆ ಡಾಕ್ಟರ್ ಹೇಳಿದ್ ಸರಿ ಇಲ್ಲ ಅಂತ ಆಯ್ತಲ್ಲ. ಮಿಸ್ಟರ್ ಕೌನ್ಸಿಲ್, you have undergone surgery, really you have spent an expenditure, you have to produce as an additional documents. ಆಯ್ತ್ರಿ, 12 ವರ್ಷ ಆಯ್ತಲ್ಲ, ರಿಮೂವಲ್ ಆಗಿದೆಯಾ ಇಲ್ಲ, ಎಲ್ಲಿ, ವೇರ್ ಇಸ್ ದ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ಐ ಆಮ್ ಆಸ್ಕಿಂಗ್. ಮತ್ತೆ ಮಿಸ್ಟರ್, ಯು ಆರ್ ನಾಟ್ ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ವಾಟ್ ಐ ಆಮ್ ಸೇಯಿಂಗ್. ಮತ್ತೆ ಈ ಲಾ ಇಸ್ ಪರ್ಮಿಟೆಡ್. If there is any this thing, additional documents can be produced under Order 41 Rule. ಆಯ್ತಪ್ಪ, ಅಲ್ಲಪ್ಪ, ಮಾಡ್ಬೇಕಾ? ಫಸ್ಟ್ ರಿಮೂವಲ್ ಮಾಡ್ಲೇಬೇಕಾ? ಆಗಿದ್ಯಾ ಫಸ್ಟ್ ಹೇಳ್ಬೇಕಲ್ಲ. You produce that. You have to produce, otherwise how can I consider? Yes, that's all, Mr. Mahesh. Can dispose of.
Please.
Amenities ಕೊಟ್ಟಿದಾರಲ್ಲ, amenities enjoyment of life 10,000. ಆಯ್ತ್ರಿ, 3 ತಿಂಗಳು ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ವಲ್ರಿ. ಮತ್ತೆ ಎಷ್ಟು ಬೇಕು ನಿಮ್ಗೆ? ಆಯ್ತು, ಐ ವಿಲ್ ಕನ್ಸಿಡರ್ ಯುವರ್ ಸಬ್ಮಿಷನ್. That's all. 2008 accident, mister. Up to ಆಯ್ತಾಯ್ತು, ಅದನ್ನ ಹೇಳಿದ್ನಲ್ಲ. ಆಲ್ರೆಡಿ ನಾವು 15 years is over. ಅಷ್ಟೇ, that's all. ಆಯ್ತ್ರಿ, you have argued, I will consider. Yes, doctor evidence. Shri, what is your name? Ganesh? Rajendra, appearing for SV Prakash, has submitted that due to that accident, the claimant has suffered grievous injury. Doctor has assessed the limb disabilities is 90%. The tribunal has considered whole body disabilities is 20% is on lower side. Already, ಯಾವ ಡಾಕ್ಟರ್ ಯಾರು who is that which ಪಾಲಾಕ್ಷಪ್ಪ ಅವರು ಎಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ 90% ಡಿಸಬಿಲಿಟಿ? ವಾಟ್ he said? ಆಯ್ತರೆ ಸಿ is evidence, ಮಿಸ್ಟರ್. ಹಾಫ್ ಪೇಜ್ is evidence. ಎಲ್ಲಿದೆ? Where is his evidence? Read that. ಹೆಂಗೆ ಯಾವ ಬೇಸಿಸ್ ಮೇಲೆ ಎಲ್ಲೈತೆ? Each component he has to explain as per that guidelines. He said that 20 ರಿಂದ 25% ನನ್ಯತೆ, 30 ರಿಂದ 35. Where is that, Mr. Explanation? Straight away on your submission, I have accepted. I said that I will enhance 10%. There is no evidence. I said that he has given each component and he has given 90%. See is the evidence, Mr. You show your chief examination which components he has explained. Have you seen that how they have to give an example? Mate, how can that 10% can be enhanced? Where is that? See, by more arguing, now you are reducing another 10% of the enhancement. I have not seen that evidence. ಹಳೆ ಕೇಸ್ ಮುಗಿಸೋಣ. He has ಒಂದು ಪೇರದಲ್ಲಿ ಈ ಎಲ್ಲಾ ಅಂಶಗಳನ್ನ ಪರಿಗಣಿಸಿ ನಾನು ಅರ್ಜಿದಾರ ಎಡ ಕಾಲಿಗೆ ಸಂಬಂಧಪಟ್ಟ 20 ರಿಂದ 25% ಅಂಗನ್ಯೂನ್ಯತೆ, ಬಲಗಾಲಿಗೆ ಸಂಬಂಧಪಟ್ಟಂತೆ 35 ಅಂಗನ್ಯೂನ್ಯತೆ, ಎಡಗಾಲಿಗೆ 40%. This is the way he has to give. That is not, Mr. ಆಯ್ತು ನೀವು ಜಾಸ್ತಿ ಮೋಟಾರ್ ವೆಹಿಕಲ್ಸ್ ಕೇಸಲ್ಲಿ ಅಪಿಯರ್ ಆಗಿಲ್ಲ, ನಿಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಬಿಡಿ. ಆಯ್ತು you want to argue further, I will say that 20% is correct. Yes. As a doctor has deposed that the claimant has suffered 90% limb disability, the tribunal has taken 20% whole body disabilities is on lower side. He further contended that ಏನ್ ಕೆಲಸ ಮಾಡ್ತಿದ್ರು, ಎಷ್ಟು ಸಂಬಳ ಅಂತ ಹೇಳಿದ್ರು, ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? What is your income, Mr.? ಎಷ್ಟು ಹೇಳಿದಿರಾ? Yes. He further contended that at the time of the accident, the claimant was earning 20,000 per month. The tribunal has considered the monthly income of the claimant as 3,500 is on lower side. Further contended that due to that accident, the claimant has suffered grievous injury. He was inpatient for a period of. He was inpatient for more than 60 days. And he has suffered a lot of pain during the treatment. He has to suffer with disability and unhappiness throughout his life. The compensation awarded by the tribunal for pain and suffering, loss of immunities, other incidental expenses is on lower side. He further contended that due to the accident, he has undergone surgery. He required he has examined the doctor. Doctor has deposed that he required 1,50,000 for future medical expenses. The tribunal has not granted any compensation under that head. Hence, he sought for enhancement of compensation. Per contra, Shri O. Mahesh, Learned Counsel appearing for respondent number 4, and Shri Keshav Prashant, Learned Counsel appearing for respondent number 3, has contended that even though the claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Therefore, the tribunal has rightly assessed the notional income of the claimant as 3,500. They further contended that even though the claimant has examined the doctor as PW2, in his evidence, he has not the limb disability, and he has not assessed that whole body disabilities. Therefore, the tribunal, considering that injury suffered by the claimant, has rightly assessed the whole body disabilities as 20%. They further contended that the injuries suffered by the claimants are minor in nature. Considering that evidence of doctor and injury suffered by the claimant, the tribunal has granted just and reasonable compensation. Lastly, they have contended that the interest awarded by the tribunal, 7%, is on higher side. Hence, they start for dismissal of the appeal. Heard the learned counsel for the parties arose judgment and award. It is not in dispute. The claimant has suffered has suffered an injury in a road traffic accident occurred on 21/5/2008 due to rash and negligent driving of driver of pickup van bearing registration number KA17A6745. He has suffered an injury due to the accident collision of pickup van bearing registration number KA17A6745 and LME Tata mobile vehicle bearing registration number KA22N1161. Due to that extent, the claimant has suffered the following injury. He has examined the doctor as PW2. Doctor, in his evidence, he has not explained the limb disability, considering that evidence of the doctor and injury suffered by the claimant. I am of the opinion that the whole body disabilities can be assessed 30%. Even though the claimant has claimed that he was earning 20,000 per month, he has not produced any document to establish the same. Under that circumstances, the notional income has to be assessed as per the guidelines issued by Karnataka Legal Service Authority. For the accident occurring in 2008, the notional income has to be considered as 4,500. At the time of the accident, he was aged about 20, 21, 25 years. The multiplier applicable to the age group is 18. Accordingly, loss of future earning has been reassessed as follows. Due to the accident, the claimant has suffered the aforesaid injury. He was inpatient for a period of 60 days. He has suffered a lot of pain during the treatment. He has to suffer this disability and unhappiness throughout his life. Considering that evidence of doctor and injury suffered by the claimant, I am inclined to enhance the compensation for loss of immunities from 10,000 to 25,000. Loss of income during the later period for 3 months, 4 months. Due to the accident, the claimant has suffered the aforesaid injury. He has undergone surgery. Considering that injury suffered by the claimant, I am of opinion that the claimant is required 20,000 for future medical expenses for removal of the implants. Enhanced compensation amount carries 6% interest. The respondent number the IFCO Tokyo General Insurance Company is directed to deposit 75% of that award amount, and Mandala Insurance Company is directed to deposit 25% of the award amount with interest within 2008 ಅಲ್ಲಿ 40,000 ಬೇಕಾದಷ್ಟು ಆಯ್ತು ನಿಮ್ ಇಂಜುರಿ. ನಾವ್ ಈಗಲೇ 50,000 ಕೊಡ್ತಾ ಇದೀವಿ. ಅದನ್ನ ನೋಡಿದೆ ನಾನು, ನೋಡ್ಬಿಟ್ಟೆ ಸುಮ್ಮನೆ. ಐ ಹ್ಯಾವ್ ಸೀನ್ ದಟ್ ಇಶ್ಯೂ. Yes.
Number 68.
60. Yes. Right, ಬೆಳಿಗ್ಗೆ. Yes, none appear. Release this matter of 2 weeks. Yes. Literal earlier, madam. What is this, Mr. Yes. Yes. 35 and 65. Yes. Yes. Yes, petitioner one has stated that he has. PW one has stated that he has sustained previous also. Correct. PW is the driver of offending vehicle. Yeah, that one of the bus. That accident has attempted to avoid mistake by taking the bus to extreme right side. That is the vehicle and. He was not on that bus. Yes. Fell down and sustained injury. Caused that accident on the right side of the road. Petitioner came in contact with the vehicle and the vehicle came in contact. There is an award from the cost respondent. Stated that accident has occurred due to the involvement of the bus. That is, the entire blame is on the petitioner. It is put whole responsibility on the driver. Road when we are passing the road has come from the. Left side was the complaint from the admitted is found that near the. He was crossing the road. Equally responsible for the public to fix the road. Yes, where is it? What about that distinct income? ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ? ಇನ್ಕಮ್ ಎಷ್ಟು ತಗೊಂಡಿದ್ದಾರೆ 4500 13 ಗೆ ಎಷ್ಟಿದೆ 8000 10 2010 ಆಕ್ಸಿಡೆಂಟ್ 10 5500 ಟೋಟಲ್ ಎಷ್ಟಾಗಿದೆ ಜಾಸ್ತಿ ಬಟ್ we can round up that for, see, we can round up for 1 lakh. ಅವಾಗ ಅವರಿಗೆ 75 ಸಿಗುತ್ತೆ. ವೆರಿ ಸಿ ಚೇಂಜ್ ಆಗಿಲ್ವಾ? ಸರಿದೆಯಾ? Let us see password. 74 Keshav Prashant.
Yes, my lord, I appear for the response.
74 for appellant. Keshav Prashant.
Is there any liability dispute?
No, madam. It's only about
enhancement.
Quantum, my lord.
Yes. What is the date of the accident? 2013. Can you see? 592.
ಹೌದು.
592 illegal discussion.
CH about 18 years.
592 ಅಲ್ವಾ?
ಹೌದು. Paragraph number 22 ಇಂದ ಸ್ಟಾರ್ಟ್ ಆಗುತ್ತೆ. Page
22. Yes. What is his age? 22.
18 years.
18 years.
Was a student.
Student.
Second PU student ಅಂತ ಇದು ಮಾಡಿದ್ದಾರೆ. Tribunal Mallard held that he was an non-earning person ಅಂತ ಹೇಳಿ. ₹5,000 Mallard income is considered. But Mallard, while deducting the Mallard, it was personal expenses deducted to 1/3. He was a bachelor. Time by mother and sister.
Yes. No, that 2013. Yes, madam. What is this? Hmm. Hmm.
The produced SLC certificate will have PU first year certificate. Was studying in
ಅದು ಇನ್ನೊಂದು ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟರ್ ನಡೀತಾ ಇದೆ 5 ನಿಮಿಷ
produce both of these documents are also. Tribunal has taken income as
5,000. Yes.
Very less.
What is the deduction?
Deduction is
future prospect is not added.
Not added.
Not added.
ಮಾಡಿಲ್ಲ. 1/3 ಮಾಡಿದ್ದಾರೆ ಡಿಡಕ್ಷನ್ 50% ಆಗಬೇಕು.
50 ಮಾಡಬೇಕು.
50 ಮಾಡಬೇಕು. ಫ್ಯೂಚರ್ ಪ್ರಾಸ್ಪೆಕ್ಟ್ಸ್ ಆಡ್ ಮಾಡಬೇಕು. And the compensation granted and conveyance rates is 1,50,000. Recalculate ಮಾಡಬೇಕಾಗುತ್ತೆ.
Law of dependency. Yes, we will recalculate and take that 8,000 as income. Deducting
Student.
No, if the person.
Malad is a student, Malad. Is not.
Even person major, as per the guidelines, 8,000. I am taking that.
ಜಾಸ್ತಿ ಆಗುತ್ತೆ.
No, that you show me that any judgment in respect of that minor who has studying SSLC. Any, see, in respect of that, engineering students, final year engineering, the court has taken 15,000. That is to accident of the year 2000, 18, 17 and 18. This is of the year 2013. I'm taking 8,000. Not 10,000. If you want 8,000, I will do it here.
ಜಾಸ್ತಿ ಸ್ವಾಮಿ. Non-earning person.
That for that he is objecting.
Non-earning person. Tribunal has
Yes,
considered 5,000 rupees. Deduction 1/3 ಅಂತ ನಾವು 5,000 ತಗೊಂಡಿದ್ರೆ 1/3 ಮಾಡಿದ್ರೆ ಅಂತ we have not filed appeal. Otherwise, we not 50%.
Yes. So learned counsel appearing for the claimant has contended that at the time of the accident, deceased was aged about 18 years. He was studying in second PUC. He has a bright future. The tribunal has assessed the notional income of the claimant as 5,000 per month is on lawyer side. So if he further contended that in view of judgment of apex court in case of Pranay, the 40% of the income of the deceased has to be added for future prospects. How many persons are there for
Mother and sister, my lord, 2 persons.
Yes. Therefore, she is sought for enhancement of compensation. For contra, 3. Keshav Prashant, learned counsel appearing for insurance company, has contended that deceased was a non-earning member and he was a minor. Therefore, the tribunal has rightly assessed the notional income of the claimant deceased as 5,000 per month. He further contended that deceased is a bachelor. The tribunal, instead of deducting 50% of the income of the deceased for personal expenses, has error in deducting 1/3. Lastly, he has contended that the compensation awarded by the tribunal for other conventional head is on higher side. The same is contrary to the law laid down by apex court in case of Pranay. Hence, he sought for. Therefore, he has contended that the overall compensation awarded by the tribunal is just and reasonable. Sought for dismissal of the appeal. Heard the learned counsel for the parties. There's judgment and award. It is not in dispute. Rafiq died in road traffic accident occurred on. What is the date? 3/2/2013. Due to rash and negligent driving of car bearing registration number AA20Z0317. At the time of the accident, he was aged about 18 years. He was studying in second PUC. Considering his education qualification and his future prospects, I am of the opinion that the monthly income of the deceased can be considered as 8,000 per month. In view of law laid down by apex court in case of Pranay, 40% of the income of the deceased has to be added for future prospect. Deceased is a bachelor. 50% of the income of the deceased has to be deducted for personal expenses. The multiplier applicable to the age group is 18. Accordingly, loss of dependency has been reassessed as follows. 2,200 rate of 40%, 11,200 minus 5,600 at the rate of 50%, 5,600. 7,600 into 12 into 18, 1,09,600. In addition, 15,000 for loss of estate, 15,000 for funeral expenses. The claimants are entitled 40,000 each for love and affection. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified as follows. The insurance company is directed to deposit their compensation amount with interest within 6 weeks from date of this. Yes. 73.
Much obliged.
Yes, madam. What is that? There is contributory negligence. You have crossing that road that is meant for the vehicle. Therefore, you have not examined the doctor. Therefore, we will enhance the compensation from 53,000 to 1 lakh. And liability, in respect of that, this contributory negligence will be retained. 75-25. Yes. Well, so and so, learned counsel appearing for the claimant has contended that the accident is occurred due to the negligence of driver of the bus bearing registration number AP28Z2959. The tribunal is error in held that the claimant is contributed 25% to the tax extent. She further contended that due to the tax extent, the claimant has suffered grievous injury, was inpatient. How many days? He was inpatient for a period of 4 days. He has suffered a lot of pain during the treatment. The compensation awarded by the tribunal is on lower side. Hence, he sought for enhancement of compensation. C.D. Vijay Kumar. C.D. Vijay Kumar, learned counsel appearing for the corporation, has contended that the accident is occurred due to the contributory negligence of the petitioner. The petitioner has contributed 25% to the tax extent. The tribunal has rightly held that petitioner has claimant has contributed 25% to the tax extent. He further contended that the injuries suffered by the claimants are minor in nature. He has not examined the doctor. Considering that injury and the evidence of the parties, the tribunal has rightly assessed the compensation of rupees 53,500. Hence, he sought for dismissal of the appeal. Heard the learned counsel for the parties. Peruse 3 papers. The claim of the case of the petitioner that when he was returning back to his village, proceedings towards the KSRTC bus stand, here in Bangalore, in Vetamangala, Bangapete bus platform, when he was crossing the road, the driver of the bus bearing registration number APSRTC AP28Z2959 came in rash and negligent manner, dash against the climate. Due to impact, he sustained injury. Yes. Considering that the evidence of the parties and considering that sketch and Mazur charge sheet, the tribunal has rightly held that the claimant has contributed 25% to the tax extent and driver of the bus has contributed 75% to the tax extent. In respect of quantum, due to the tax extent, the claimant has suffered grievous injury. He was inpatient, Siglilwa. As he was inpatient for a period of 4 days, he has suffered a lot of pain during the treatment. Considering that injury suffered by the claimant, I am of the opinion that the compensation, the overall compensation awarded by the tribunal, 53,500 has to be enhanced to 1 lakh with interest. Accordingly, the appeal is allowed in part. Judgment and award passed by the tribunal is modified. The corporation is directed to deposit 75% of the award amount with interest within 6 weeks from date of inspection. Full bench ಒಂದು 64 ಅಕ್ಷರ.
ನೀವು ಬಂದ್ರಿ